an individual. Nominee can be only an individual. Okay, nominee cannot be a proprietorship firm, whereas a proprietorship firm can nominate, but a proprietorship firm cannot be a nominee. Okay, nominees will be only single individuals in the case of a deposit account. Coming to safe custody article, I told you if the safe custody article is deposited in single name only, then nomination is permitted. If they are deposited in joint names, nomination is not permitted. Then who will be the nominee for the safe custody article? Again, only single individual. Single individual is only nominee for the safe custody article. So who can nominate and who will be the nominee? Both we should know. Then locker. If it is operated single name and operated singly, or in the proprietorship name, again nominee can be a single individual only. Then locker. Locker, if it is a joint names, again I repeat, locker is in joint names and nomination rule is applicable only if the locker is operated jointly. Where you can find it? So that is a death claim manual updated till 30/9/2021, uploaded in your CANAT. You can see. So locker, if it is in joint names, if it is operation jointly only, nomination is eligible. Then who will be the nominee? Only individuals can be a nominee. There can be more than one individual also. So you see, deposit, only single individual. Safe custody article, only single individual. Locker, in single name, only single individual. In the case of a locker, in joint names, when operation condition jointly, there may be more than one individuals or also can be nominees. Okay, sir. Then these are all the form numbers. Clerical to officer exam, they are asking the question, what is a form number for registration or addition for nomination, for cancellation or variation for nomination, deposit, safe custody article, single locker, locker join, capital gains account, etc. Okay, these you have to go through it. There is no meaning again I repeating on all these slides. Already the slide is uploaded in CBOA website. Then insolvent person. And so an insolvent person, insane person cannot nominate for his account. An insolvent person, an insane person cannot nominate for his account. As per RBI guidelines, nomination is compulsory in single named accounts. For example, you are opening an account in the name of Mr. Ramasamy. You have to ask for nomination. If Ramasamy says he does not want nomination, then you have to tick the appropriate box in the account opening form. Then in the nomination form, if you see the deposit opening form, witness column will be there. Witness 1 and witness 2. Witness for nomination is required only if the account depositor is an illiterate. If the depositor is a literate, that is if he signs the deposit account opening form or if he signs the nomination form, then witness for nomination is not required. This question they are frequently asking. So witness, even though witness column is there in the nomination form, witness to witnesses is required only if the depositor is a illiterate. Otherwise, there is no need for witness for nomination. Witness for nomination is needed for illiterate deposit accounts or whatever accounts you are opening. Printing of nomination is registered is mandatory in deposit receipts and passbooks. So name of the nominee need not be printed in the passbook or in the deposit receipt. So by default, whenever there is a nomination, create the nominee ID, link it with the deposit ID. Then automatically when you print the deposit receipt, nomination registered will appear there. If the depositor wants the nominee name also to be printed, then only the nominee name to be printed in the deposit receipt. Okay. Nominees are to be individuals only. Again, I am telling you, no. So HUF cannot be a nominee. HUF cannot nominate. HUF cannot be a nominee. Similarly, a company cannot nominate. A company cannot be a nominee. A partnership firm cannot nominate. It cannot be a nominee. A trust cannot nominate. It cannot be a nominee. On the other hand, a proprietorship account can nominate. But a proprietorship account cannot be a nominee. They cannot be nominees. So nominee can be a minor. Nominee can be a minor. I told you minor cannot nominate. A minor cannot nominate, but a nominee can be a minor. If the nominee is a minor, there should be a major who has to receive the money on behalf of the minor. Okay, nominee can be a minor. In that case, person to receive the money to be indicated against the name of the guardian. For gold loans here, you see, so I told you nominee can be a minor, but for gold loans, minor cannot be a nominee. It is an exception. Again, I repeat, minor cannot nominate, but a minor can be a nominee. For gold loan, minor cannot be a nominee also. For gold loan, minor cannot be a nominee also. All account holders have to sign the nomination form. Whatever may be the operation condition, all account holders have to sign the nomination form. So nomination can be cancelled, varied, and any number of times under the signature of all the account holders. Okay, so any number of times it can be varied subject to whatever charges bank is going to charge. And then this question they're asking, who are all the nominees? Nominees are also called as the trustees of the legal heirs. Nominees are also called as the trustees of the legal heir. What do you mean by nominees are called as the trustees of the legal heir? So nominee is coming, legal heirs are also coming. There is a nomination. You settle the death claim in favor of nomination. If the legal heirs goes to court, then it is between the legal heir and the nominee to get the money or give back the money, etc. Bank has to no role to play. So nominees are called the trustees of the legal heir. So again, as I told you, a proprietorship account can nominate, but it cannot be a nominee. Again, I repeat, nominees are single individuals only. In the case of locker operation jointly, nominee may be more than one individual. Nominee need not sign the nomination form. Okay, no, you are not asking nominees. You are just asking name of the nominee, relationship with the depositor. If the nominee is the minor, a guardian, then you are asking the relationship. That's all. You are not asking anything else. Nominee need not sign the nomination form. Illiterates can nominate for their account, and illiterates can be nominees also for some other deposit accounts. Then nominee can be any individual. The nominee need not be related to the, that is, account holders. Nominees can be any individuals. Now, in joint deposit accounts, nominee right arises upon the death of all depositors. For example, you are having a deposit in the name of A and B. Operation either or survivor, or operation jointly, or operation number one or survivor, or operation farmer or survivor. So when you will give the money to the nominee, money will be given to the nominee only when all the depositors die. So in joint deposit accounts, nominee right arises upon the death of all the depositors. Then branches to settle nomination. So the question of whatever may be the deposit amount, it may be 1 crore, 1 lakh, 10 crores, 5 crores, whatever it is, or locker, or safe custody article, or gold loan. Wherever there is nomination, branch in charge has the full power to settle nomination. So it need not be referred to RO, CO, etc. The amount of 2 lakhs, 5 lakhs, etc. is given is only for settlement of death claim without nomination. Okay, then now in joint locker accounts, operation jointly, nominee can be more than one individual. I already told you. See, now I am going to explain a very important concept, settlement of death claim in the case of a deposit account and in the case of a locker account. See, you imagine locker account, operation jointly, nomination is eligible. Locker account, operation jointly, nomination is eligible. For example, let us assume if locker is in the name of A and B, operation jointly. Nomination, they have made nominees or X and Y. Nominee can be more than one individual. Upon the death of Mr. A, so locker, operation jointly, A has died. Upon the death of Mr. A, to whom you will settle the death claim? we will settle the death claim. In the case of a locker, operation jointly, when nominee is there, we will settle to be the surviving locker hirer along with the nominee or nominees. So there are two nominees are there. So you will settle the death claim in favor of Mr. B along with Mr. X and Mr. Y. Upon the death of Mr. A, contents to be vacated and death claim to be settled and given to Mr. B and Mr. X and Mr. Y, nominee or nominees. The legal heir of A will not enter into picture. So locker operation jointly, when there is a nomination, if one of the locker hirer dies, settlement of death claim will arise in favor of the nominee or nominees along with the surviving locker hirer. The question of that is legal heir of the deposit, deceased depositor will not enter into picture. You see the next slide. In the case of a deposit account payable jointly, deposit account payable jointly. So only if A and B dies, nominee will enter into picture. Here, there what you have seen, A and B operation jointly locker. A dies. You are settled the death claim in favor of Mr. B along with Mr. X and Mr. Y nominee. You say you take a deposit payable jointly. A and B are there. If one dies, so nominee will not enter into picture. You have to settle the death claim in favor of the surviving depositor along with the legal heir of the deceased depositor. In deposits payable jointly, only if A and B dies, nominee will enter into picture. If A only dies, settle to B and legal heirs of say A, since it is payable jointly. Okay, very important. There is a difference between a locker settlement jointly and deposit account jointly. Okay. All the forms are required, documents for settlement, death certificate, claim form number 147, then proof of identification of the nominee like Aadhaar, DL, passport, etc. Let's not worry about it. Then you have to obtain the stamped receipt from the nominee whenever death claim are settled, irrespective of the amount. So not the question above 5,000, 10,000, etc. Irrespective of the amount, the final receipt obtained from the nominee for death claim settlement should be a stamped receipt. Okay, when legal heir and nominee approaches the bank, claim to be settled in favor of the nominee. Okay, whenever both legal heirs and nominees are approaching the bank, you settle the death claim in favor of the nominee. But there are certain exceptions to it. So, then what is the exception to it? If there is a succession certificate, a nominee is coming and a succession certificate holder is coming. A nominee is coming and a succession certificate holder is coming. Who issues the succession certificate? Court issues the succession certificate. What do you mean by succession certificate? It is a legal heir certificate. When the Tahsildar issues or the revenue officials issues the certificate, we call it as legal heir certificate. But when a court issues the same certificate, we call it as succession certificate. So a succession certificate holder is coming. He says money to be given to me only. A nominee is coming. He says money to be given only. Since the succession certificate is issued by the court of law, even though nominee is there, you will settle the death claim in favor of the nominee, in favor of the succession certificate holder. On the other hand, a legal certificate holder is coming. Who issues the legal certificate? Tahsildar or revenue official. A legal certificate holder is coming as well as a nominee is coming. In that case, you have to settle in favor of the nominee only. On the other hand, if a succession certificate holder comes, you forget about the nominee, settle in favor of the succession certificate holder. Similarly, if a probate holder is coming, and a nominee is also coming, who is a probate holder? So when a person deceased, he writes a will. When a person has deceased, he writes a will and the will is certified by the court of law. A person has died and he has written a will, and in the will he says, I have a deposit with Canara Bank, the money should go to Mr. X only. But whereas the nomination he has given to Y in your bank. Okay, so the nominee is coming, Y is coming, Mr. X is also coming with the will. So the will should be got certified by the court. When the will got certified by the court, it is called probate. So he is the probate holder. The person named in the will is the probate holder. He brings the will. He says, my name is in the will, money to be settled for me. The nominee is also coming. Since the probate, it is probated. Since the will is certified by the court, you have to settle the death claim in favor of the probate holder, even though nominee is there. And the third place, a person is bringing an order from the court. A person is bringing the order from the court, restraining the bank from not paying the money to the nominee. Then also, you should not pay the money to the nominee. Okay, normally we have to settle the death claim in favor of the nominee only as per rules wherever nomination is there. But there are three exceptions to it. What is the first exception? When a succession certificate holder comes, you settle the money in favor of him even though there is nomination. When a probate holder comes, you settle the claim in favor of the probate holder even though nomination is there. And the third one, when a person is receiving a court order asking the money to be payable to him and restricting not to pay the money, you have to abide by the court order. If there is a succession certificate or a probate holder approaches the bank, and if there is a court order restraining the bank from making payment to the nominee, bank has to abide by the succession certificate holder or a probate holder or court order. So these are all the things with regard to nomination. Quickly, let us see the questions with regard to nomination. Then we'll go to the death claim. Section 45 is a C in Banking Regulation Act. So the Banking Regulation Act talks about various sections with regard to registration of nomination and settlement of nomination. 45 ZA, 45 ZB, that is for deposit. Then 45 ZC and 45 ZD, that is for safe custody article. Okay, so section 45 ZC in Banking Regulation Act refers about registration of nomination and deposit. No. Right of set off? No. Registration of nomination in safe custody article? Yes. For question number 78, answer is C. Question number 78, answer is C. If you see the PowerPoint presentation, you will understand which are all the other sections for registration of nomination and cancellation of nomination. Those sections you should be thorough, very simple sections. So for question number 78, answer is C. Question number 79. What is the form number for registration of nomination under capital gains account? The form number is NF733. NF733 is the form. So all the form numbers I have given there. Only a model question I have given here. NF733. These form numbers are being asked from clerical to officer. Okay. Can an insolvent person be nominee? So the question is whether, now again I repeat, whether a minor can be a nominee. Yes, minor can be a nominee. If minor is a nominee, another major should be there. Whether an insolvent person can be a nominee. Yes, insolvent person can also be a nominee. If there is an insolvent person as the nominee, then when somebody, the account holder dies, you cannot give the money to the insolvent person. Then whenever there is an insolvent person is the nominee, then an official receiver, okay, an official receiver should be there to receive the money. Okay, so insolvent person can also be a nominee. Whenever there is an insolvent person, like a minor, guardian is there, no? Like that for an insolvent person, official receiver or official assignee given by the court should be there to receive the money whenever the account holder dies. So for minor, guardian. For insolvent person, official receiver or official assignee. Yes, whether the answer for the question is, can an insolvent person be nominee? Yes, he can be a nominee. The legal status of a nominee is as that of trustees of the legal head. The legal status of a nominee is as that of trustees of the legal head. Question number 82. Whether a proprietorship firm can be a nominee for a deposit account. I told you proprietorship firm can nominate, but a proprietorship firm cannot be a nominee. So what is the question? Whether a proprietorship firm can be a nominee for a deposit account? No. Only individuals can be the nominee. So proprietorship firm cannot be the nominee. No. The answer is no. Question number 83. There is a joint, please read the question. This type of questions they are asking for all levels. So there is a joint SB account in the name of A and B, operation jointly. Joint SB account in the name of A and B, operation jointly. Only when both A and B signs a check, the check will be passed. They nominated X for this account. They nominated X for this account. When A dies, to whom the money to be given? So when an account is operated jointly, when one of the depositor dies, I told you, wherever there is a nomination in a deposit account, nominee right arises upon the death of all depositors. Here, who has died? Only A has died. So B has not died. So there is nomination. Upon the death of A, the nominee will not enter into picture. Give the money to Mr. B, the surviving depositor, along with the legal heirs of the deceased depositor. So, since the deposit is payable jointly, account is operated jointly, upon the death of one of the depositor, the money to be given to the surviving depositor along with the legal heirs of the deceased depositor. So, question number 83, answer is D. So, give to B and legal heirs of A. Question number 84. There is a joint SB account in the name of A and B, operation severally with survivorship clause. What is that survivorship clause? I will tell when we go for death claim. Okay. There is a joint SB account in the name of A and B, operation severally. What do you mean by operation severally? Any one of them can operate the account with survivorship clause. They nominated X for this account. When A dies, to whom the money to be given? You see here, when it is operated jointly, when A dies, you are given the money to Mr. B along with the legal heirs of A. So nominee has not entered into picture. Nominee will enter into picture only when all depositors die. Similarly, here also, there are account in the name of A and B, operation either or survivor. When A dies, so nominee will not enter into picture. Then to whom you will give the money? You will give the money to Mr. B because operation is either or survivor with a survivorship clause. So when A dies, to whom the money to be given? The money has to be given to Mr. B. Legal heirs of A will not enter into picture like the previous question. So question number 84, answer is A. Question number 84, answer is A. Question number 85, joint locker in the name of A and B. Operation jointly. B dies. Nomination in favor of X, I told you. In the case of a locker, operation is jointly, nomination is permitted. When one of the locker hirer dies, you settle the death claim in favor of the surviving locker hirer along with the nominee to whom the locker access to be given. Question number that is 85. Question number 85. To whom the locker access to be given. You see, who dies? A, B dies. Nomination in favor of C. So you have to give the locker access to Mr. A along with C. A and C. So question number 85, answer is D. So if you sit at home and read question number 83, question number 85, and question number 85, you will get a clarity. So for question number 85, answer is D. Question number 85, answer is D. Question number 86. Joint locker in the name of A and B, operation severally with the survivorship clause. So B dies. So what do you mean by severally? Any one of them can operate, either or survivor. I told you, locker operation jointly only nomination rule is applicable. If it is not jointly operation, nomination rule is not applicable. So joint locker in the name of A and B, operation severally with survivorship clause. B dies. So when B dies, since it is either or survivor, you allow A to operate the locker and take the content to whom the locker access to be given. The locker access to be given to Mr. A. Question number 86, answer is A. Question number 86, answer is A. Question number 87. So these questions, 84, 85, 86, that is, sorry, 83, 84, 85, 86, you please go through once. Any doubt is there, you can talk to me. So these type of questions, they are asking frequently for all levels. At the examination point of time, you should be sure to attend the question within a fraction of a second. Okay, question number 87. A term deposit account with repayment condition either or survivor. Deposit is in the name of X and Z without survivorship clause for 2 years. X dies after 1 year of opening the deposit. Z approaches the bank for payment of deposit before maturity to him. Nominee is Mrs. X, to whom the payment to be made. So please read the question again. A term deposit, question number 87 we are seeing now. A term deposit account with repayment condition either or survivor. Okay. So deposit is in the name of X and Z. So without survivorship clause. Now I will explain what is survivorship clause. Sir, the concept of survivorship clause is applicable for deposits in the names of more than individual or locker or whatever it is. When it is in the name of more than individual, the survivorship clause is applicable provided the operation condition or the repayment condition is either or survivor, number one or survivor, former or survivor. So the survivorship clause is not applicable for operation jointly. Survivorship clause is not applicable for payment of the term deposit jointly. So other than jointly, if it is either or survivor, number one or survivor, former or survivor, etc., there is a clause in the account opening form called survivorship clause. So you know the deposit is the name of A and B. Operation, that is either or survivor. When one depositor dies in the bank, what we do? We delete the name of the deceased depositor and give the money to the surviving depositor either before maturity or on maturity. Isn't it? How so then based on what we are doing it, so whenever the deposit is the name of two individuals, either or survivor or number one or survivor, former or survivor, when one dies, we give the money to the survivor. So actually, we have to give to the survivor along with the legal heir, but we are not doing it. We are doing it only in the case of deposit payable jointly because survivorship clause is not applicable for jointly payable deposit. What is survivorship clause? If you go through the account opening form, there is a clause. What is that? It says, we have made the deposit in the event of death of any one of us. In the event of death of any one of us, bank has the right to give the money to the surviving depositor or surviving depositors without the consent of the legal heir of the deceased depositor. Again, I repeat. So what is survivorship clause? So in the event of the declaration given by the account holders at the time of opening the account, in the event of death of any one of us, bank has the right to give the money to the surviving depositor or surviving depositor or depositors without the consent of legal heirs of the deceased depositor. This is called the survivorship clause. But this survivorship clause is not applicable for deposits payable jointly. It is applicable for deposits payable either or survivor, number one or survivor, former or survivor. Based on this survivorship clause, in the case of either or survivor, so when one depositor dies, we remove his name and allow the other person to operate the account or give the money to him. So the account opening form normally consists of the survivorship clause. So whenever we say joint account, either or survivor, number one or survivor, former or survivor, it means it is with the survivorship clause only. In the question paper, if they give without the survivorship clause only, you have to open your eyes and ears. Otherwise, we have to assume that it is with the survivorship clause only. Okay, now we explain what is survivorship clause. This clause is applicable to what types of repayable conditions and what we are supposed to do. Now you see question number 87. A term deposit account with repayment condition either or survivor. Deposit is in the name of X and Y without survivorship clause for 2 years. X dies after 1 year of opening the deposit. Z approaches the bank for payment of deposit before maturity. Nominee is Mrs. X. See, so it is either or survivor. You forget about nominee. Nominee rate will arise only when both the depositor dies. So it is a either or survivor. One depositor dies. So that is the surviving depositor is asking you to give the money. Then you have to see the question whether it is without survivorship clause. So without survivorship, if there is a survivorship clause, you can give the money to the surviving depositor without the legal heir. If there is no survivorship clause, then you have to give the money to the surviving depositor along with the legal heirs of the deceased depositor only. So specifically they have told it is without a survivorship clause. When there is no survivorship clause, whether it is operation is either or survivor, number one or survivor, farmer or survivor, don't give the money to only one person. You give the money with the survivor along with the legal heirs of the deceased depositor. Question number 87, your answer should be, that is answer is D. What is the answer? So Z is the survivor along with the legal heirs of X. X is the deceased depositor. Question number 87, answer is D. Question number 88. Death claim. This question they are frequently asking. Death claim to be settled within dash days after submission of all claim papers by the claimant. So within, that is 15 days. Question number 88, answer is B. Question number 88, answer is B. So after giving all the papers, it has to be settled within 15 days. Question number 88, answer is B. Question number 89. Succession to the estate of the deceased. So we have seen so far what is known as death claim in settling in this case of nomination. So when the nominee enters into picture, etc. Now we are going to see death claim without nomination. So before going to the question, let us quickly go through the PowerPoint presentation. Death claim without nomination. Okay. I think this yeah, we already see. So this I think I have not told you. I see. I told you that is in the case of a nomination. So whenever deposit is the name of a minor, and if it is represented by guardian, guardian can sign the nomination form. But there are certain exceptions to it. What are they? In the case of a Canara tax saver, if it is the name of a minor represented by guardian, guardian cannot nominate for that account. Capital gain accounts. If it is the name of a minor represented by guardian, guardian cannot nominate for that account. Sovereign gold bond. So can tax saver, capital gains account, and sovereign gold bond held in the name of a minor represented by guardian, nomination is not permitted. This is an exception. Okay, then how many maximum number of nominees can be there in a deposit account? Whatever may be the number of depositors, nominee will be only one individual. In the case of a locker, operation jointly. In the case of a locker operation jointly, the nominee can be more than one individual. Capital gains account, what is the maximum number of nominee? 3. Payment will be made to whom? First nominee if he is alive. If he is not alive, you give the full money to the second nominee. If the second nominee is also not there, give the money, full money to the third nominee. Okay, then senior citizen savings scheme, maximum number of nominees are 4. That is provident fund scheme, maximum number of nominees are 4. Suganya Samriddhi account scheme, maximum number of nominees are 4. Sovereign gold bond, maximum number of nominees are 2. You should not miss out anything under nomination. Minor, as I told you again, minor can be nominee, but they cannot be nominee for gold loans. Minor cannot be nominee for gold loans. Okay, now we are going to see death claim without nomination. So death claim without nomination. Now, so death claim settlement in accounts without nomination, when it will arise. So where you forget about there is no nomination, let's assume. So you are going to settle a death claim. So when the death claim without nomination will arise, for example, a single account holder dies. There is no nomination. Then death claim will arise. You have to give the money to the legal heirs of the account holder. In joint accounts, operation jointly. In joint accounts, operation jointly. When one or more than one depositor dies, but not all depositors. Joint accounts, operation jointly. When one depositor or more dies, but not all of them, then settle the death claim in favor of the surviving depositors with the legal heirs of the deceased depositor. Then death claim in the case of a joint accounts. So when operation jointly, if all depositors dies here, one depositor or two depositor dies, settle the death claim in favor of the surviving depositor along with the legal heirs of the deceased depositor. In joint accounts, that is operation jointly, all depositor dies, settle the death claim in favor of the legal heirs of all the depositors. So single depositor dies, legal heirs of the single depositor. Joint operation, when one dies, settle the death claim in favor of the survivor along with the legal heirs of the deceased person. Joint operation, all depositor dies, settle the death claim in favor of the legal heirs of all the depositors. In other types of repayment condition, I told you, no, only either or survivor, number one or survivor, farmer or survivor, survivorship clause is applicable. Normally, claim to be settled in all other types of repayment condition, claim to be settled in favor of the survivor with the legal heirs of the deceased. Normally, in all other conditions also. But however, we are not settling the death claim in the case of either or survivor, along with the survivor, along with the legal heir because of the survivorship clause. But in either or survivor, if one dies, we delete the name of the deceased and allow the other to operate the SB, or in term deposit, close the deposit and give it to the survivor without the legal heir. How? This is due to the survivorship clause is available in the account opening form. Okay, so when one dies, in the case of either or survivor, when one dies, get the death certificate and delete the name of the deceased person. Survivor wants before maturity, close before maturity. If the survivor wants to keep the deposit in his name till maturity, permit him to keep. If all the depositor dies, either or survivor, all the depositor dies, then you have to settle the death claim in favor of the legal heirs of all the depositors. Okay, sir. Then number one or survivor. If number one dies, get the death certificate of the number one, delete his name and give the money to the survivor because of the survivorship clause. If all die, both number one and all other depositors also dies, then settle the death claim in favor of the legal heirs of all the depositors. Similarly, farmer or survivor. If farmer dies, delete the farmer's name, allow the survivor to operate the account. If both dies, death claim to be settled in favor of the legal heirs of both the farmer as well as the survivor. Okay, so when the death claim to be settled, suppose if the depositor has left a will, if the depositor has left a will, then you have to settle the death claim as per the will of the deceased person. This is called testamentary disposition. When you are settling the death claim based on the will of the deceased person, we call it as testamentary disposition. So whenever the will, you have to get the will probated by a court in places where it is needed. Based on the probate or based on the will, you settle the death claim. This is called testamentary disposition. If there is no will, most of our death claim settlements in the bank where there is no nomination, we do what is called intestate disposition. When a person has written a will, it is called a testamentary disposition. When a person has not written a will, to whom you will give the money? To the legal heirs. So that is called intestate disposition. So when there is a no will, you give the money to the legal heirs of the deceased person. This is called intestate disposition. Succession law by which the deceased is governed. Who are all the legal heirs? So the legal heirs, who are all the legal heirs of the deceased person? You have to settle to them. This is called the intestate disposition. Who are all the legal heirs? The legal heirs of the deceased person depends upon the succession law by which the deceased is governed. For example, when a Hindu male is dying, who are all the legal heirs? When a Hindu female is dying, who are all the legal heirs? Similarly, other religion, when they are dying, who are all the legal heirs? So you have to decide who are all the legal heirs and give the money to the legal heirs according to their share. That is called intestate disposition. For example, there are three types of legal heirs: first class legal heir, second class legal heir, and third class legal heir. When the first class legal heirs are there, you have to give the money to them only. So when the no first class legal heir, when the second class legal heirs are there, you have to give the money to them. Then there are no first class or second class, then you have to give to the third class legal heirs. Okay. For example, a Hindu. In a Hindu male dying intestate. What do you mean by a Hindu male dying intestate? A male Hindu dying intestate means without writing any will. He dies without writing any will. If he has died by writing a will, it is called testamentary disposition. A Hindu male dying intestate. Who are all the legal heirs of a Hindu male dying intestate? The legal heirs are wife, children, mother. All of them should get the equal share. Okay. So Hindu male dying intestate. Similarly, if a Hindu female dying intestate, a Hindu female without writing any will, she dies. To whom you will settle the money? You will settle the money to the legal heirs of the Hindu female. Who are all the legal heirs of the Hindu female? Husband and the children. Mother is not there. All of them will get the equal share. Okay, you should know the legal heirs. Settlement of death claim by the succession law by which the deceased is governed is called a dash. Once they ask it. Succession, the settlement of death claim based on the succession law by which the deceased is governed is called a dash. It is called intestate disposition. Settlement of death claim based on a will of the deceased is called testamentary disposition. Okay, sir. So for different religions, legal heirs will vary. The share also will vary. So what is the share, etc. So let us not worry about it. All death claim to be punched in the internal portal. The claimant can track the status. All claims to be settled within 15 days from the date of submission of all claim papers. Okay. Then who is the authority for settling the death claim? This is settlement of death claim without nomination. Managers, senior managers in charge of branches, they have power maximum 2 lakhs. And then scale 4 heading branches, 3 lakhs. Scale 4 in regional office, scale 5 heading branches, 5 lakhs. Scale 5 in ROs, 10 lakhs. DGMs are having full powers. Okay. Locker and safe custody article, DGMs are having full powers. Scale 4 and 5 heading branches, if they go on leave beyond a period of 7 days, powers for the manager and senior manager in the branch is 2 lakhs. This is for settlement of death claim without nomination. If there is a nomination, these upper limits are not there. Irrespective of the amount, branch in charges can settle. Then, in respect of gold loan, the appraised value given in the gold loan application is the criteria to find out the amount. In the case of a gold loan, not the present market value. The appraised value given in the loan application is the criteria. In respect of other securities like shares, etc., the present market value is the criteria. You see, for gold loan, the appraised value given in the gold loan application is the criteria. In respect of other securities, the present market value on the date of settlement, like deposit, on the date of settlement is the criteria. For deposits, principal with interest on the date of settlement is the criteria for delegation. The assets in the name of the account holder in all the branches of the bank is the criteria for delegation, not only in one branch. Under the custody, what are all the deposits are there, what is the locker is there, etc., to be taken into account to assess the death claim, who is the delegated authority. Claim amount up to 10,000, claim come declaration form, appendix form number 2 of the manual. Claim above 10,000 up to inclusive of 50,000. This is simple claim declaration form as per appendix 3 of the manual. Then if the claim amount is above 50,000, then the form number is NF1020. Okay, so claim amount up to 50,000, above 50,000, about up to 10,000, above 10,000 up to 50,000, above 50,000. The form is NF1020 with its annexures. Okay, let's not see the PowerPoint presentation. Let's quickly see the questions. You will understand. Now we will answer the question. Now, question number 89. Succession to the estate of the deceased person based on the will of the deceased person is called. So succession to the estate of the deceased person based on the will of the deceased person is called testamentary succession. So what do you mean by that? Succession means what? The legal heirs to the estate of the deceased person. So estate means property, property of the deceased person based on the will of the deceased person. When a person dies after writing a will, it is called testamentary. Okay, so succession to the estate of the deceased person based on the will of the deceased person is called testamentary succession. Question number 89, answer is C. This question once they ask. Question number 89, answer is C. Question number 90, settlement of death claim based on the succession law by which the deceased is governed. So we are settling most of the death claim based on this only. Whenever there is a will, it is called a testamentary succession or testamentary disposition. When there is no will, it is called intestate disposition. A person dies without writing a will, it is called intestate disposition. Then settlement of death claim based on the succession law. Who are all the legal heirs? Depends upon the religion to which the deceased person belongs to. So settlement of death claim based on the succession law by which the deceased was governed is called intestate disposition. Question number 80, testamentary disposition. This is intestate disposition. 89, 90. 91. What is the power of a manager or senior manager in a branch headed by scale 4 or scale 5 and the absence of the branch in charge is beyond 7 days on settlement of death claim? Already I told you. Question number 91, answer is D. For managers and senior managers, it is only 2 lakhs. Okay, question number 91, answer is D. NSCs are pledged to overdraft. The face value of the NSC is rupees 2 lakhs. The market value is 2.5 lakhs. To determine the delegation of settlement of death claim, which one to be taken? Face value, no. Market value to be taken on the date of settlement of death claim. Question number 92, answer is B. Question number 93, claims in respect of deposit accounts, up to what amount claim can be settled without a death certificate? You see, friends, so death claim can be settled even without the death certificate. So as per your manual of instructions on death claim updated till 30/9/2021, claims in respect of deposit accounts, up to what amount claim can be settled even without death certificate? Up to 50,000 rupees. Question number 93, answer is B. Without insisting on death certificate, so you can settle the death claim for deposits up to 50,000 rupees. Okay. What is the form number for death? So question number 93, answer is B. Question number 94. What is the form number for death claim settlement beyond 50,000? NF1020. NF1020. Claims up to 50 dash can be made to one or more claimants, preferably to the widow of the deceased, without insisting on the signature of all the claimants. See, first what I told you, claim up to 50,000 can be settled even without the death certificate. Now, claim amount, so that is, there are 4 or 5 legal heirs are there. Without asking the signature of all the legal heirs, you can settle the death claim to one or more legal heirs, leaving the signature of all the legal heirs, preferably to the widow of the deceased person. Up to what amount? Up to 10,000 rupees. Question number 95, answer is 10,000. So claims up to 10,000 can be made to one or more claimants, preferably to the widow of the deceased, without insisting on the signature of all the claimants. Up to 10,000. Then surety to join the letter of indemnity if the death claim is above, that is 5 lakhs. So if the death claim amount is above 5 lakhs, 2 sureties to join. If the death claim is above 5 lakhs, then 2 sureties to join. Surety to join the letter of indemnity in death claim if the amount is rupees 5 lakhs and above. Question number 96, 5 lakhs and above. Claim papers are to be preserved for how many years? Always there is a dispute in this question. So people say for 21 years, some people say permanently. See friends, as per HO Circular 221/2022, that is document and records retention policy, document handling policy and records retention policy. Every year, bank is coming out with the policies. Current year, document handling policy and records retention policy, HO Circular 221/2022. As per that circular, claim papers, claim files, nomination papers, and nomination file to be preserved permanently. Okay, question number 97, answer is permanently. So there is somewhere I have seen 21 years, etc. But your records retention policy and document handling policy, it is saying it is permanently. Question number 97, answer is permanently. HO Circular 221/2022. Will certified by the court is called, I told you, no, when a person dies, tested. What do you mean by a person dies tested? He has written a will and he has died. When the will is got certified by the court, it is called probate. Probate. Will certified by the court is called probate. Question number 98, answer is probate. Question number 99. Crime settlement of missing person is covered under which act? Hello? Okay. Okay. So claims, okay, sorry. Question number 98, will certified by the court is called probate. Claim settlement of missing person is covered. So before that, you should know who is a missing person. So for example, a person is not traceable. So when a person is not traceable, what generally people will do? They will lodge a police complaint. After lodging the police complaint, that is FIR, 7 years they have to wait. So after lodging, when you come to know a person is missing, an FIR is lodged. After lodging the FIR, so you have to wait for 7 years. After 7 years, the relatives will go to the court of law. The court will give you a certificate. So that is equivalent to the death certificate. A missing person. Who is a missing person? A person who is not traceable. Even after 7 years from the date of lodging the FIR is called a missing person. The certificate will be issued by the court. Based on that, death claim will be settled. Whether branch managers are empowered to settle the death claim in the name of missing person? Yes. If it is a domestic term deposit, up to 50,000 rupees. And if the person is missed within India, then branch in charges are empowered to settle the death claim in favor of the missing person's deposit accounts only. Up to 50,000 rupees, domestic deposit, and if the person has missed within India. So after 7 years, after getting the court order, so he is called a missing person, equivalent to person who has died, death claim can be settled. Okay, so claim, so if they ask the other questions, you should not ask whether branch in charges are having powers to settle the death claim of the missing person. Yes, so missing person who was not traceable after 7 years from the date of the FIR, based on the order given by the court, we call it as missing person. So branch in charges can settle up to 50,000 rupees domestic deposit, and if that person has missed within India. Okay, claim settlements of missing persons is covered under which act? That question they are asking. Question number 99. So it is covered under Indian Evidence Act. Please note it down. Claim settlement of missing person is covered under Indian Evidence Act. Indian Evidence Act. So from question number 99, 2-3 probable questions also I told you. That is why you have to hear the video again and again. Claim settlement of missing person is covered under Indian Evidence Act. Question number 99, answer is Indian Evidence Act. Question number 90, whether the branch headed by scale 2 can settle nomination under safe deposit locker. So I told you that is nomination to be settled by the branch in charge only, whether it is a deposit irrespective of the deposit amount. That is safe custody article, other is safe deposit locker, branch in charges only to settle. So answer is, so whether it is, what is the options? No, it has to be settled by CO. No, that is wrong. No, it has to be settled by RO. That is also wrong. No, it has to be settled by HO. That is also wrong. None of these. So question number 100, answer is D. Question number 100, answer is D. The correct answer is nomination to be settled by branch in charge only. Okay, question number 100, answer is D. Question number 101, your branch is having a deposit account in the name of a minor represented by father as guardian. Please read the question carefully. This question was asked not in our bank, it's some other bank for 3 to 4. Your branch is having a deposit account in the name of a minor represented by father as guardian. There is no nomination in this account. Your minor's account represented by father as the guardian. There is no nomination in this account. The minor dies. If there is a nomination, you'll give the money to the nominee. But there is no nomination. To whom the money to be given? Father, mother, guardian, legal heirs of the minor. Friends, please understand, when an account is opened in the name of a minor, the money belongs to the minor. The guardian is only operating the account on behalf of the minor for the benefits of the minor. When the minor dies, you should not give the money to the guardian. You should not give the money to the father, grandfather, etc. When the minor dies, in the case of an account operated by a guardian, when there is no nomination, when the minor dies, the money to be given to the legal heirs of the minors, legal heirs of the minors. Question number 101, answer is D. Minors also have legal heirs. Question number 1, for example, as per Hindu law, if a minor girl dies, mother is the 100% legal heir. In the case of a Hindu law, if a minor boy dies, both father and mother will get 50-50% share. Okay, so in the case of a deposit account of a minor represented by guardian, if there is no nomination, settle the death claim in favor of the legal heirs of the minor. Question number 101, answer is D. Question number 101, answer is D. Question number 102. You come to know the death of a depositor of a branch through his nominee who comes to the branch to get the money with the death certificate. At that time, the legal heirs also, along with the High Court advocate, also approach you with a plaint they filed in a court requesting the court to instruct the bank not to give the money to the nominee. Payment to be made to nominee, to the legal heirs, pay jointly to legal heirs and nominee, wait for the court order, refer to RO. Friends, I told you, whenever there is a nomination, WhatsApp video. Online class la iruken koopra. So you could, that is when there is a nomination in a deposit account, when there is a nomination in the deposit account, you have to settle the claim only in the favor of the nominee until 3 exceptions. Succession certificate holder comes, probate holder comes, and a court order comes, then you cannot pay the nominee. Here, if any court or succession certificate holder has come, no. Any court order has come, no. Any probate holder come, has no. Only a plaint filed in the court. Court has not given the order. So in this case, settle the death claim in favor of the nominee. Question number 102, answer is A. So question number 102, answer is A. Question number 103. Mr. A has SB account in his name and he nominates his minor son, okay, as the nominee for this SB account. So Mr. A has SB account in his name, and you know, minors can be nominees. Whenever the minor is a nominee, there should be a major to receive the money on behalf of the nominee. Who can be the major? The major can be anybody. It is not necessary the major should be the guardian of the minor only. Okay, Mr. A has an SB account in his name and he nominates his minor son as a nominee for his SB account. Since the nominee is a minor, he has to appoint another major person on behalf of the nominee. The major person should be mother, close blood relative, any person, guardian. He can be any person to the minor. A major who can enter into contract on behalf of the minor, his name should be there. Okay. So question number 103, answer is C. Question number 103, answer is C. Friends, quickly we will go through other legal aspects. Only the answers are very important. Quickly you have to go through it. So questions, answers will be coming now. Lien is defined in which act? Before that, on the day itself, I told you what is lien. Okay, when you understand the concept of lien, then you will understand a general lien and particular lien. And I always told you, I have been telling you, banker is having a general lien. General lien is defined under section 170 of the Indian Contract Act, and particular lien is defined under section 171 of the Indian Contract Act. Lien is defined under the Indian Contract Act. What is lien? I give an example. You are given a loan to a borrower, housing loan. House is taken as a security for the loan. Okay. After some time, that person is coming and he is asking a loan against there is some NSC. Let us assume he wants an OD against NSC. So you are giving loan against OD against the NSC also. So you are taken different types of documents. Suppose then he has cleared the OD. Let's assume he has cleared the OD. Now he wants you to release the NSC to him. So before release the NSC, you find out that the housing loan is having arrears. The housing loan is having arrears. He has given security house as the housing loan, and he has given the security NSC for the OD account. Now, since that the housing loan is having arrears, bank has the right. So bank has the right to retain the security given for one loan. So till the overdues in the other loan is cleared. So even though there is no overdue in the OD, he has cleared the full liability, he wants you to release the NSC. But at that time, before, for example, gold loan, you say, he has taken a gold loan from you. He is having an housing loan also. Housing loan has become overdue. Gold loan he has taken and he is going to take back the gold from you. He has paid the money. At that time, you are telling, I will not release the gold ornament until you clear the overdues in the gold loan. This is called general lien. Banker is having a general lien. However, before enforcing the general lien, certain formalities have to be complied with. Otherwise, it will create a lot of confusions at the branch level. Okay, so what is lien? Lien is defined where the right of the creditor is the bank. The right of the creditor to retain the one property that is which is taken as a security for one loan till the overdues in the other loan is cleared is called right of the lien of the security creditor. So where it is defined in the Indian Contract Act. What is a particular lien? Particular lien means gold loan is taken. When the gold loan is cleared, you have to release the security to him, gold ornament, without seeing the overdues in that housing loan. That is called a particular lien. Banker is always having a general lien only. The general lien is also called implied pledge. The general lien is also called implied pledge. Okay, question number 104, answer is Indian Contract Act. Question number 104, answer is C. Question number 105. Banker's lien is implied pledge or general lien. Question number 105. Answer is A. I explained to you what is implied pledge or general lien. Question number 105. Answer is A. Question number 106. The right of the banker to adjust the deposit account to the loan account of the same person is called as what? So, a borrower is having a deposit account. The borrower is also having the loan account. So the loan account has become overdue. He has not repaid the overdue even after you send notices, etc. Then you find out there is a deposit account in his name. Then send a notice to the borrower. So stating that you are having a deposit account. If the loan overdues are not cleared, I will close the deposit and adjust to the loan account. This is called as a write-off set-off. So question number 106, the right of the banker to adjust the deposit account to the loan account of the same person is called a write-off set-off. Where write-off set-off is defined, write-off set-off is not defined anywhere. It is by practice of the banker. Question number 107, write-off set-off is defined in which act? It is not defined. It is by practice of the banker. Write-off set-off can be used if simultaneous relationship available between the banker and the customer is dash and dash. What I told you, what is write-off set-off? You are having a borrower is having a deposit account. The borrower is having a loan account also. When the loan account is overdue, send notice to the borrower stating that I am going to close the deposit or adjust to the loan account. That is called a write-off set-off. Okay, so for write-off, the exercise to write-off set-off, bank should have both loan account and deposit account. So in the case of a deposit account, the relationship with the bank and the customer is debtor and creditor. In the case of a loan account, the relationship with the bank and the customer is creditor and debtor. So to exercise the write-off set-off, bank should have deposit accounts, bank should have the loan account in the name of the borrower, the name of the depositor. This is called the write-off set-off. That means bank should have, that is, simultaneous relationship of debtor creditor and the creditor debtor. Write-off set-off can be used if simultaneous relationship between the bank and the customer is dash and dash. Bank is the debtor, customer is the creditor, deposit account, and bank is the creditor, customer is the debtor, that is the loan account. So question number 108, answer is A. Question number 108, answer is A. Question number 109. Suresh has here, so this is very important question. If you understand this question, you can apply for all the cases. Suresh has a SB joint farmer or survivor account with his wife Seema. So he is having a SB account, joint account. Okay, he is having an SB account, joint account. Forget about the operation condition. See, farmer or survivor, either or survivor, jointly, number one or survivor, they are only operation condition. Forget about the operation condition, friends. So he is having a joint SB account with his wife Seema. He also has a loan account in his name, which is in NPA. So SB account is in joint name, loan account is in his name. Before submitting the loan card, branch wants to exercise that. Submitting the loan card means, so take a further action. So branch wants to do exercise the write-off set-off, whether branch can do. Write-off set-off can be exercised. Similarly, lien also can be exercised only when, for example, if the deposit is in the name of A, loan is in the name of A, you can exercise write-off set-off. Again, I repeat, deposit is in the name of A and loan in the name of A, you can exercise write-off set-off. Then deposit in the name of A and B. Deposit in the name of A and B, loan in the name of A only, you cannot exercise write-off set-off. Okay, deposit in the name of A, loan is also in the name of A, write-off set-off can be exercised. Deposit in the name of A and B, loan in the name of either A or in either B, you cannot exercise the write-off set-off. Similarly, deposits is in the name of A and B, loan in the name of A and B, you can exercise write-off set-off. Now you see in whose name the deposit account, what name is in joint name. So that is Suresh and Seema. And in whose name the deposit account, loan account in the name of Suresh only. So bank cannot adjust the concept of write-off set-off here. Question number 109. So none now. See what is the question? Can be done since it is the farmer or survivor. Can be done with the consent of R&L section. Prior permission from HO is required. None of this. None of this. You cannot do write-off set-off because deposit in joint name, loan account is one name. So don't see farmer or survivor and say it can be done. Friends, again I repeat, the farmer or survivor, number one or survivor, either or survivor, jointly, etc. is only operation condition. For all other things, consent of both the people are required. Okay, so none of these. Question number 109, none of these. Question number 110. There are two firms, AB Enterprises and ZX Enterprises. Both are having the same partners. AB Enterprise has OD with your branch, which is in NPA. ZX Enterprise is in another branch of your bank with current account with credit balance. Can you write off set off both the accounts? No, since both are in different names. Can be done if both accounts are in the same branch after giving notice. Can be done if both has the same name after giving notice. Can be done after giving notice. Here, even though the accounts are in different branches, So, but since the names of the firms are different, even though the names of the branches are different, even though the two firm accounts are in different branches, since the partners of both the firms are the same, then current account of the one firm can be adjusted as write-off set-off to the loan account of another, that is another firm in another name, since partners are the same. So you can do write-off set-off after giving due notice. Question number 110, answer is D. Question number 110, answer is D. Question number 111. Contract without consideration is void as per which section of the Indian Contract Act? What do you mean by contract without consideration? When you enter into a contract for some purpose, for example, you are purchasing something from somebody. When you send these goods, I will give you the money. That is called a contract with the consideration. What do you mean by contract without consideration? You are getting a gift check from somebody. So you are not, it is not for any consideration, isn't it? Contract without consideration is void as per which section of the Indian Contract Act? Section 25 of the Indian Contract Act. Friends, these are all the legal framework questions got from various exams in the various years conducted by IBBS for various banks, including last year. Okay, contract without consideration is void as per which section of the Indian Contract Act? Section 25. Under RTA Act, which is the odd man now. What do you mean by odd man, which is wrong? So the question is, which is not correct with regard to RTA Act? RTA Act is, Right to Information Act. The applicable fees is 10 rupees. That is correct. Reply to be given within 30 days. Normally, reply to be given within 30 days. That is also correct. If the information asked for is about the liberty of a person, reply to be given within 7 days. No, that is not correct. If the question is asked for the public information officer, because something is going to happen, about we are going to release the person from the jail tomorrow, or we are going to hang the fellow tomorrow, please give reply. So if the question is asked about the liberty of a person, then the reply to be given within 48 hours. Normally it is 30 days. If the question is with regard to that is a release or that is a liberty of a person, reply has to be given not within 7 days, within 48 hours. The person asking the information need not give any reason as to why he is asking the information. Correct. There is no need he has to tell why I am asking the information. If the reply is not given 30 days or if the reply is not given 48 days, what is the penalty? 250 rupees per day, maximum 25,000 rupees. So which is the odd man out, which is wrong in Right to Information Act? Question number 112, answer is C. So the right answer is 48 hours. So question number 112, answer is C. Then safe custody article is covered under which act? So the safe custody article is covered under Indian Contract Act. Please note it down. Safe custody article is covered under Indian Contract Act. So if you see the question paper, people who have already written the exam, some questions will be 4-5 lines, some questions will be 1 line, some questions will be easy, some questions will be tough. For some questions, you have to apply your mind and write, etc. So these type of straight questions, you can immediately tick the answer and see other questions. Safe custody article is covered under Indian Contract Act. Contract of insurance is a contract of dash, or it is also called a contract of dash. Contract of insurance is a contract of indemnity. Contract of insurance is a contract of indemnity, or it is also called as a contract of utmost faith. Again, I repeat, contract of insurance is a contract of indemnity or contract of utmost faith. Okay, question number 115. When court appoints a guardian for a minor, he attains majority at what age? Okay, this is very important. Friends, before this question, I want to ask you a question. Minor is defined where? Minor is defined where? Minor is defined in Indian Majority Act. Who is a minor? Who has not completed 18 years of age. Okay. So who are all the guardians for the minor? The natural guardians, Who are all the natural guardians for the minor, Then you have If the natural guardians are not there, if the natural guardians have written a will, so the minor's name, that is the guardian, will find a name in the will. So he is called a testamentary guardian. Testamentary means will. So natural guardian, then you get what is known as testamentary guardian. If there is no testamentary guardian, court will appoint a guardian, and that guardian is called a legal guardian or court appointed guardian. There are three types of guardians for a minor: natural guardian, testamentary guardian, legal guardian, or court appointed guardian. Whatever may be the types of guardian, a minor attains majority when he completes 18 years of age. Earlier, this was earlier when the Majority Act was not amended at that time. If the minor is having a court-appointed guardian, he will attain majority only when he has completed 21 years of age. Now that has been removed. Whomsoever is the guardian for the minor, he will attain majority when he has completed 18 years of age. So question number 115, answer is A. Question number 115, answer is A. Question number 116, a minor attained majority on 1st April 2012. A check signed by his guardian, that is his father, dated 25th March 2022, that is before the minor attains majority, issued in favor of a college where he studies, presented for payment on 31st May 2012. So, he has attained majority on 1st April. Check is dated 25th March. It comes for payment after the minor attained majority. Now, whether you can pass the check. So, options are: pass the check as it is dated before the minor attains majority, pass the check as it is dated before minor attains majority and it is for college studies, which is for the benefit of the minor, return the check, get the consent of the minor, who is the major now, and then pass. Friends, once the minor attains majority, no debit should be there in the account without the consent of the minor, who is a major now. Whether the check is issued before he attains majority, etc., etc., for what purpose the check is issued, that is none of the question of the banker. What is the date of the check? What is the date in which the minor becomes major? When the checks comes for payment. If the check comes for payment after the minor attains majority, you have to get the consent of the consent of the minor, who is the major now. Then only you have to pass the check. In fact, you have to do the re-KYC. You have to do the re-KYC for the major. Then only you have to pass the check. So get the consent of the minor, who is the major now, and pass the check. 116, answer is D. Otherwise, you should return the check. So, since option C and option D are given, out of the two, D is the correct answer. If option D is not given, you have to say return the check. Okay, question number 117. Question number 117. Whether a mother can be a guardian in respect of a Muslim minor girl, whether the minors are as per the success, the religion to which that is they belong to. In the case of a Muslim, as per Muslim law, so who is the that is guardian for a minor? Who is the guardian for a minor? Father is the guardian. If father is not there, will of the father. If the father is the guardian, if the father is not there, will of the guardian, will of the father. Father has written any will, in that any guardian is mentioned. So they will become the guardian. If there is no will of the father, then father's father will become the guardian. So father, will of the father, father's father will be the guardian. If the father's father is not there, then you have to see any will of the father's father is there. So father, will of the father, father's father, will of the father's father. If these things are not there, then court will appoint a guardian for a Muslim minor girl. Then whether at any point of time, whether there is God, normally mother is not a guardian. Any point of time, whether mother can be a guardian, she cannot be a natural guardian. She cannot be a testamentary guardian. So she cannot be a natural guardian. She cannot be a testamentary guardian. She cannot be a guardian. No. So court can appoint mother as the legal heir of a Muslim minor girl. So father, then will of the father, then father's father, will of the father's father, then finally court. So father only can be the guardian. So if he has written mother as the guardian in the will, it is not applicable. Then father's father will automatically come. If father's father is not there, father's father cannot write mother as the guardian, then only court will decide. So for a Muslim minor girl, so when mother can become a guardian, she can be only a legal guardian if she is appointed by the court. 117, answer is B. Question number 117, answer is B. Question number 118. A person who writes a will is called, testator. 118, question number 118, answer is D, testator. When a person dies testate, what do you mean by a person dies testate? He has written a will and died. When a person dies testate, the succession appointed by the will is called. So in the will, he has written a person name. No, that person is called executor. So a person who has written a will is called testator. The person named in the will, that means, so when a person dies, when a person dies testate, the succession appointed by the will means the person named in the will. The person named in the will is called the executor. So question number 118, answer is D. Question number 118, answer is D. Question number 119, when a person dies testate, the succession appointed by the will is called executor. Then when a person dies intestate, what do you mean by when a person dies intestate without writing a will? When a person dies intestate, who can appoint a person or persons to look after the properties of the deceased by a letter of what? So when a person dies intestate means a person has died without a will. Then who can appoint a person? Court can appoint. So when a person dies intestate, court can appoint. So first fill up the blanks is court can appoint a person, that is persons look after the properties of the deceased by a letter of, what is that letter? Court will issue a letter. So this is the guardian. So that is a person look after the estates of the deceased person. So there is he has not given any person who has to look after it. So this is the person who has to look after the properties of the deceased person. So that letter is called letter of administration. Okay. So when a person dies by writing a will, he is called a testator. The person named in the will is called the executor. When a person has not written a will, then court will appoint a person to look after the estate of the deceased person by a letter of, that is administration. So that is called letter of administration. Okay, that is to open bank accounts, to open executor account. So what is an executor? Person named in the will. When the will is certified by the court, it is called probate. If you want to open an executor account, you have to ask for probate. If you want to open an administrator's account, who is an administrator? Court appointed person. So when a court appointed person is there, you want to open an account for them, you have to call for letter of administration. So if you want to open the letter of the account in the name of executors, so you have to ask for probate. So to open executor's account, banks insist for probate. And for administrator's account, banks ask for letter of administration. Then executors and administrators are dash for the legal heirs. Executors and administrators are the trustees for legal heir. I told you, no, nominees are the trustees for the legal heir. Similarly, executors and administrators are called the trustees for the legal heir. When there are more than one executor or administrator in the account, all of them to operate the account only jointly. That is correct. More than one executor or administrator are there, all of them to operate the account jointly. You cannot have any other operation condition. All of them to operate the account only jointly. Question number 123, answer is A. Question number 123, answer is A. but any one of them can give stop payment instruction. Okay, question number 123, answer is A. Question number 124, executors and administrators are appointed as per which act? Okay, who is an executor? So then the person named in the bill is the executor. Who is the administrator? The person named in the letter of administration is the administrator. Who appoints the executor? The deceased person in the will. Who appoints administrator? Court through the letter of administration. Okay, then the question is, executors and administrators are appointed as per which act? Executors and administrators are appointed as per Indian Succession Act. Question number 124, answer is A. They are appointed as per Indian Succession Act. Question number 124, answer is A. Question number 125. An executor or administrator can appoint an agent to operate the account. No, friends, executors and administrators cannot delegate their authority. They cannot delegate their authority. So the answer is, it is not permitted. Question number 125, answer is C. Executor, administrator can appoint an agent to operate the account. No, they cannot operate. All of them to jointly operate the account. So it is not permitted. Question number 125, answer is C. Question number 126, instructions for stop payment of a check can be given by any one executor, administrator when there are more than one executor and administrator. Friends, when there are more than one executor or administrator, all of them to sign the check. But for stop payment, any one of them can give the stop payment. Answer is true. Question number 126, answer is true. Question number 126, answer is true. Question number 127. As per Hindu law, who can form Hindu undivided family? Who can form? So Hindus can form, Sikhs can form, and Jains. Hindus, Sikhs, and Jains can form Hindu undivided family. Please note it down. Hindus, Sikhs, and Jains can form Hindu undivided family. If Karta executes the documents, whether co-parceners are eligible or liable, you know, in a Hindu undivided family, the senior most co-parcener is the Karta. He may be a male or she may be a female. Earlier, only the senior most male co-parcener will be the Karta. Now that has been removed. The senior most co-parcener, whether male or female, they can be the Karta. Okay, now the question is, suppose who has to sign the document? Karta is signing or co-parceners are signing. If Karta executes the documents, whether co-parceners are also, that is liable for the loan taken by the Karta. See, if Karta executes the documents, whether co-parceners are liable, yes. If Karta executes the document, co-parceners are also liable. To what extent the co-parceners are liable? To the extent of the share, their share in HUF, they are liable. But they are not personally liable. Again, I repeat, friends. When HUF, in the HUF, whenever they are executing the loan document, if Karta executes the loan document, co-parceners are signing the loan document. Who are all eligible? Who are all liable? Karta is liable. Karta is liable personally also. Co-parceners are liable to the extent of share in the HUF. They are not eligible. They are not liable personally. On the other hand, if co-parceners also signs the document, Karta is eligible to his share, then Karta is personally eligible. Co-parceners are liable to the extent of the share, then co-parceners are also personally liable. This question they are frequently asking. When Karta alone signs the document, when co-parceners also signs the document. So, if Karta executes the documents, whether co-parceners are liable, yes, to the extent of their share in the HUF and not personally. That is the answer for the question. Question number 129. Karta in HUF can delegate the authority to operate the account. I told you, in the case of an executor's account, administrator's account, they cannot delegate their authority. But in the case of an HUF account, Karta can delegate the authority to whom he can delegate the authority to operate the account. He can delegate the authority to some co-partners, or he can delegate the authority even to a third party. Okay, it's not necessary. Only co-partners he can delegate. He can delegate to operate the SB account or current account either to the other co-partners, or he can give the power to some third party also. So question number 129, Karta in HUF can delegate the authority to operate the account to one or more co-partners, can delegate to a third party, only to the senior most co-partner. Karta cannot delegate. Answer is E. He can give to one or more co-partners. He can delegate to a third party also. So A and B are correct. So question number 129, answer is E. Question number 129, answer is E. A co-partner who is not given authority to operate the account cannot use stop payment instruction for a check issued by Karta. Correct. This is true. So only if the co-partner has given authority to operate the account, he can use stop payment. Otherwise, he cannot use stop payment. Answer is true. Question number 131. You are having an HUF SB account without nomination. You know, that is accounts in representative capacity, you cannot give nomination. So HUF account is having an SB account. There is no nomination. When the Karta expires, the money in the SB account has to be given to whom? So HUF account, no nomination. When the Karta dies, to whom the money has to be given? When the Karta expires, the money in the SB account has to be given to all co-partners, legal heirs of Karta, senior most co-partner who becomes Karta, senior most male co-partner who becomes Karta. As per HUF document, none of these. So again I repeat, HUF cannot have a nomination. When the Karta dies, to whom you will give the money? All co-partners, legal heirs of Karta, senior most male co-partner. Then as per HUF document, none of these. The option for question number 131 is none of these. When the Karta dies, the senior most co-partner will become Karta and the money to be given to him. Here the option is the senior most co-partner. The option is senior most male co-partner. No, that is not correct. Not to all co-partners, not to legal heirs of Karta, not to senior most male co-partner. As per HUF document, no. So answer is none of these. What is the correct answer? Senior most co-partner who becomes the Karta. Okay, question number 131, answer is E. Question number 132, Mr. A. So these are all the questions are frequently asked. Few more questions which are going to run around now. So agent is there, agent dies, account holder is there, account holder dies, check dated this one, check dated subsequent this, check comes for payment, what he will do. So sometimes they will give with the date of the check, sometimes they give without the date of the check. So what are the things to be done? If you understand the concepts, you can answer any question. These questions are frequently asked by IBBS. So that is which question, sir? So question number 132. Okay, question number 132. Mr. A sole trustee died on 25th April. A check dated 10th April signed by him comes for payment on 2nd May. Pass, return, pass if permitted in the trust deed, none of these. Friends, so you have to see whether there is a single trustee in the trust account or there are more than one trustee. If there is a single trustee, if the single trustee dies and if the check signed by him comes for payment, whether you will make the payment or not. You have to see here when the check, what is the date of the check and when the trustee has died, single trustee. Okay, for example, so a sole trustee died on 25th April. Check signed by 10th April, signed by him, comes for payment on 2nd May. So the date of death is 25th April and the date of the check is 10th April. What the law says, in the case of a sole trustee account, if the check is dated before the death of the trustee, If the check is dated before the date of death of the trustee and it comes after the death of the trustee, then you honor the check. Again, I repeat, if the check is in the case of a sole trustee account, single trustee account, if the check is dated before the date of death of the trustee, and if the check comes for payment after the date of death of the trustee, honor the check. On the other hand, if the check is dated subsequent to date of death of the trustee, then do not honor the check. Now the question is, he has died on 25th April. The check is dated 10th April. So the check comes for payment on 2nd May. So the check is dated before the date of death of the sole trustee. So you can pass the check. Question number 132, answer is A. Question number 132, answer is A. Question number 133. Your branch receives a letter from Mr. A, the sole trustee of a trust account, authorizing Mr. B to operate the account during his absence out of India. What he will do? Accept the authorization letter, accept only if it is notarized, accept only if it is registered, don't accept. Friends, a trustee cannot delegate his authority to anybody else. Okay, so he can be a sole trustee when he leaves India. Nobody else he can give power to operate the account. So do not accept. Question number 133, do not accept. Answer is B. Question number 134. Your branch receives a check issued by a trustee on the trust account. You come to know that he has become insolvent. This check has to be passed if all other things are in order for the reason trustee is alive, balance is available in the account, it is a check issued on the trust property, none of these. Okay, the logic for this question, the legal aspect is insolvency of a trustee will not affect the trust property. Again, I repeat, insolvency of a trustee will not affect the trust property. Before this question, I will ask you one question, sir. See, you come to know your account holder has become insolvent. Your drawer, your account holder has become insolvent. You got a letter in confirmation. So by the time a check comes for payment, signed by your account holder, who has become insolvent? Your account holder has become insolvent. So the person who has signed the check, you are having the account, so he has issued a check. You come to know before the check comes in clearing or across the counter that your account holder has become insolvent. In that case, whether you will pass the check? No. If you come to know the account holder has become insolvent, you have to return the check with the reason drawer's confirmation required. Again, I repeat. So this is, I'm not talking about the trust account, normal. So when your account holder becomes insolvent, you have to return the check with the reason drawer's title requires confirmation. Now you come to trust account. Now you have seen in the case of an individual account, when the account holder becomes insolvent, you have to return the check with the reason drawer's confirmation required. Sorry, drawer's title required, not confirmation, sir. Drawer's title required confirmation. Drawer's title requires confirmation. Okay. Now here, the trustee has become insolvent. Trust account is there, the trustee has become insolvent, he has signed the check. So in this case, the insolvency of the trustee will not affect the trust property. Insolvency of the trustee will not affect the trust property. You can pass the check. Okay, your branch has issued a check, your branch received a check issued by the trustee on the trust account. You come to know that it has become insolvent. So this check has to be passed if all other things are in order for the reason it is a check issued on the trust property. Okay, so insolvency of a trustee will not affect the trust property. Question number 134, answer is C. Question number 135. Whether a minor or insolvent person can be an agent, whether minor can be an agent, yes, minor can be an agent. Whether insolvent person can be an agent, yes, they can be an agent. Okay, so but they cannot appoint agents. Minor cannot appoint agent. Insolvent person cannot appoint agent, but they can be agents. Okay, question number 135, answer is B. Okay, as no, yes, they can be agents of majors. Whether minor or insolvent person can be agent? Yes, they can be agents of majors. Question number 135, answer is B. Question number 136. So these few questions you see, so some explanation I will give. You will answer any question that is asked in the exam. Whether a check signed by an agent can be passed even after his death when all other things in order. Here, friends, date of the check is not given. So, okay, don't break your head. Date of the check is not given. But it is told the agent has died. Whether a check signed by an agent can be passed even after his death when all other things is in order. Let us assume Mr. A is your account holder. He has given the mandate to Mr. B to operate the account. So that is a check signed by Mr. B, the agent comes for payment. At that time, you come to know that Mr. B, the agent, is no more, whether you will pass the check. See, as long as nothing has happened to the account holder, as long as nothing has happened to the account holder and nothing has been told about the date of the check, so this check can be passed if otherwise in order. What is the question? Whether a check signed by an agent can be passed even after his death when all other things in order. What do you mean by all other things are in order? The check is in order, account holder is alive, so it is not a stale check, balance is in the account, signature tallies. In such cases, you can pass the check. So no, yes. Question number 136, answer is B. See, now this question is given without a date. Sometimes they will give with a date. You see the date. A check signed by the agent. The date of the check is 10th April. So the previous question, they are not given the date of the check. Here, a check is signed by the agent. The date of the check is 10th April. The agent died on 1st April. Okay, the check comes for payment on 12th April. Will you pass the check? So what is the law says? So question number 137 we are discussing. Question number 137 we are discussing. So the check is dated 10th April. The agent has died on 1st April and the check comes for payment on 12th April. If the check is dated before, sorry, if the check is dated before the date of death of the agent, if the check is dated before the date of death of the agent, or if the check is dated subsequent to date of death of the agent. Here, what is the date of the check? 10th April. When the agent has died, 1st April itself. Checks dated after the date of death of the agent, if they comes for payment, should not be passed. Here, the check is dated 10th April. The agent died on 1st April. So this check should not be made for payment. Will you pass the check? No. On the other hand, if the check is dated 30th March, when the agent has died on 1st April, checks dated before the date of death of the agent can be passed. The first point is date of the death check is 10th April, but he has died on 1st April. This check cannot be passed. The second question is date of the check is 30th March. He has died on 1st April. Date of the check is before the death of the agent. This check can be passed. First check should not be passed. The second check can be passed. Okay, these are all the questions they are asking. 138. You see the question. A check issued by an agent comes for payment. You come to know that the principal account holder has died. The date of the check is 1st November and the date of death is only 8th November. Pass the check or return the check. Friends, seeing the date before or after, etc., is only for the agent. If the account holder has died, whether the check signed by the account holder or the check signed by the agent, there is no question of seeing the date of the check. Again, I repeat, if you come to know that your account holder has died, if you come to know your account holder has become insolvent, don't see anything. Who has signed the check? What is the date of the check, etc., etc. If you come to know the principal has died, you should not debit the account. Okay, here the question is, a check issued by an agent comes for payment. You come to know that the principal has died. In that case, you have to return the check. Don't see the date, etc. That seeing the date, etc. is applicable only the check agent has signed the check comes for payment. Here the agent has signed the check, the principal has died. Once you come to know the principal has died, what is the date of the check? Who has signed the check is immaterial. You should not pass the check, return the check. Question number 138, answer is return the check. Question number 139. SB account of this question they ask. SB account operation can either or survival. Check signed by A. Alterations are made in the check is authenticated by B. Pass since it is either or survival. Return. Get the consent of A and pass. Refer to RO. Friends, the condition either or survivor, number one or survivor, farmer or survivor, they are only operation condition. So one has signed the check, another one has made alterations authenticated. So it is not an operation condition. Operation, either one of them can sign the check, that's all. So in such a case, the options given to you are pass, it is either or survivor, no. Return, then you see other option. Get the consent of A and pass. So either you can return or you can get the two options are there. Return the check or get the consent of A and pass. So get the consent of A and pass who has signed the check. So don't give answer pass since it is either or survivor. So get the consent of A and pass the check. Okay. So locker operation either or survivor. A reports the key lost. So B comes with the key after A left to operate the locker. Permit since it is operational either or survivor. Do not permit. Permit with the consent of A. So this is also permit with the consent of A. If this option is not there, for example, permit with the consent of A, then you have to say do not permit. So your option C is not there, then you have to take the option do not permit. So the operation condition locker is either or survivor. One person comes and says the locker key is lost. The other person is coming with the locker key. Get the consent of the person and permit operation. If that option is not there in your question, say do not permit. So here for question number 140, answer is C. Question number 141. Aadhaar has how many alpha numerals? Friends, you know, Aadhaar has is only numerals, 12 numerals. So alpha numeral other than the option. Answer for the question is other than the option. Similarly for PAN, UTR, then IFS code, everything you should know. Okay, what is the Aadhaar number? So UTR is having alpha numerals or only alpha or only numeral. Similarly, your Aadhaar has alpha, PAN is having alpha numeral, etc. All those things you should know. That is given. I given one example. Aadhaar has how many alpha numerals other than the option given? Question number 142. When a guarantor on payment of all dues of the principal debtor, he gets the right of subrogation. So guarantor is there in an account, principal borrower is there. So you ask the borrower to repay the loan, he has not repaid. You ask the guarantor, he has repaid the loan. When the guarantor has repaid the loan, you have to give all the documents what you are having of the principal borrower to the guarantor. Okay, all the securities you have to give back to the guarantor because guarantor has paid the dues. Guarantor steps into the shoes of the creditor. Who is the creditor? Bank is the creditor. When the guarantor pays all the dues of the principal borrower, guarantor gets into the shoes of the principal creditor. Creditor is the bank. The right the guarantor is getting is called the right of subrogation. Question number 142, answer is D. Question number 142, answer is D. Question number 143. Friends, we'll finish these 219 questions. We'll wind up the day. Credit information companies are created under which act? Question number 143. Credit information companies are that is created under which act? So they are that is created under CIC, that is Credit Information Act 2005. Credit Information Companies Act 2005. So credit information companies are created under CIC Companies, Credit Information Companies Act 2005. Who will be appointed by the court in the case of an insolvent to realize the assets, if any, belonging to the insolvent? A person has become insolvent. Who will appoint another person? Court will appoint. What is the name of the person who has appointed to receive the money on behalf of the insolvent by the court? He is called official receiver or official assignee. Who will be appointed by the court in the case of an insolvent to realize the assets, if any, belonging to the insolvent? So who will be appointed? Official receiver or official assignee. Okay. Minor is defined in Indian Majority Act. Okay. Question number 1 to 145. Minor is defined in Indian Majority Act. 145, answer is D. 146. Incapacity of a minor to enter into contract is defined in Dash Act. I told you, no, minor cannot enter into contract. This is told where? Indian Contract Act. So, incapacity of a minor to enter into a contract is defined in which act? That is Indian Contract Act. One more question related to it. Even though minor cannot enter into a contract, banks are permitting minor to operate an account, issue a check, endorse a check. This is as per which act? This is as per section 26 of Negotiable Instrument Act. So, minor is defined in the Indian Majority Act. Then the question is, minor cannot enter into contract as per Indian Contract Act. In spite of that, minors are permitted to open SB account and operate, issue checks, etc. This is as per section 26 of Negotiable Instrument Act. All the three acts you should know. Okay, so question number 146 is Indian Contract Act. Question number 146, Indian Contract Act. Question number 147. A document is defined in which act? A document is defined in which act? A document is defined in Indian Evidence Act. Question number 147, answer is B. A document is defined in Indian Evidence Act. Okay, question number 148. Form 60 obtained from the customer on 20th October 2021. This has to be preserved till what day? So I will tell you that is income tax rule, then you give me the answer. Form 60 obtained from the customer to be preserved for a period of 7 years from the end of the financial year in which it is obtained. Again, I repeat. Form 60 obtained from the customer to be preserved for a period of 7 years from the end of the financial year in which it is obtained. Okay. Now, not for 7 years from the date it is obtained. 7 years from the end of the financial year it is obtained. Okay. So here the form 60 is obtained from the customer on 20th October 2021. So till what date it has to be preserved? 7 years from the end of the financial year. What is the end of the financial year? So you obtained on 20th October 2021. So the end of the financial year is 31st March 2022. So when a Form 60 is obtained in October 21 means it is obtained in the financial 2021. So the end of the financial is 31/3/2022. Form 60 obtained from the customers to be preserved for 7 years from the end of the financial year in which it is obtained. So from 31/3/2022, it has to be preserved for 7 years. That is till 31/3/2029. It has to be preserved till 31/3/2029. Whether options are there? No, options are not there. The answer is none of these. The correct answer is 31/3/2029. Then Form 15G and 15H obtained from the customers are preserved for how many years? That is also for 7 years, because Form 15G, 15H we will obtain for the financial year. Okay, it is for 7 years. Question number 149, answer is B. Which is not correct? Question number 150, which is not correct in respect of Form 60, which is being obtained from the customer. You are obtaining Form 60, no, for various types of transactions, which is not correct. The question is, which is not correct. You read the options, you will understand. In respect of individuals who is less than 60 years of age, if the expected annual income mentioned in form number 60 is more than 2.50 lakhs, Form 60 not to be obtained without getting a proof for having applied for PAN. Point number B. Form number 15G, 15H can be accepted with form number 60 if PAN number is not available. Form for small saving schemes, form 60 can be obtained with the condition that PAN will be provided within 6 months of account opening. Form 60 obtained from customers to be submitted to the income tax department in a form called form number 61 online on half-yearly basis on 31st October and 30th April. All are correct. Now the question is which is not correct? Friends, here the not correct option is point number B. See, 15G, 15H when the customer gives, you should accept only if he gives PAN number. If he does not give the PAN number, you should not accept Form 60 and accept 15G and 15H. What is option number B? Form 15G, 15H can be accepted with Form 60 if FAM is not available. That is not correct. So question number 150, answer is B. All other points are correct. So question number 150, answer is B. Question number 151. For a transaction, the TDS to be deducted is 25%. You have to deduct a TDS of 25%. The assessee has not provided PAN. He has not given the PAN number. Then what is the TDS to be deducted for this transaction? 20%, 25%, 45%, none of these. Friends, I will give an example. You will understand the concept. See, you know, TDS on term deposit to be deducted at what percent, sir? TDS on term, interest on term deposit to be deducted at the rate of 10%. If it exceeds 40,000 rupees for a general person and senior citizen above 50,000 rupees in a financial year, TDS to be deducted at the rate of 10%. If he has not given PAN, at what rate you will deduct TDS? At the rate of 20%. So again, I repeat, if TDS deducted rate, what rate you have to see? Whether he has given the PAN or not, you have to see. So TDS rate to be deducted is 10%. He has not given the PAN, then you have to deduct 20%. So whichever is higher, TDS rate, or if PAN is not given 20%, whichever is higher, you have to deduct. So what you are doing, if you are not giving the PAN number, then interest on term deposit, you will deduct TDS at 20%. You will not deduct, system will deduct. If PAN number is given, interest on TDS will be deducted only 10%. Here you see, the TDS to be deducted for the transaction is not 10%, 25%. So if PAN is not given, 20%. Transaction rate is 25%. Whichever is higher, you have to deduct. So don't pick the answer A. So you have to deduct 25%. The rate to be deducted or the rate without PAN. The rate normally without PAN is 20%. Whichever is higher to be deducted. Here for question number 151, answer is B. Question number 151, answer is B. Question number 152. What is the amount of term deposit that can be paid in cash? Amount of term deposit. Question number 152. That can be paid in cash. Less than 20,000 including interest, up to inclusive of 20,000 including interest, less than 50,000. Answer is less than 20,000 including interest. Question number 152, answer is A. This question number 154 was asked last time for scale 2 to 3 in Canara Bank. So question number 152, what is the amount of term deposit that can be paid in cash less than rupees 20,000 including interest? So the above is defined in which section of which act? So the above is defined in section 269, okay, or 269T. The above is defined in section 269T of Income Tax Act, okay, 1961. So term deposit less than 20,000 with interest only to be paid in cash. This is told where? It is told in section 269T, T for train, 269T of Income Tax Act 1961. Suppose if you have to pay cash, you should not pay in cash. If you are paid in cash, let us assume 25,000 rupees you are paid in cash. What is the penalty? The amount you are paid in cash is the penalty. 25,000 rupees is the penalty. This is told in which act? That question was asked in scale 2 to 3 last time. So all of us know less than 20,000 only to be paid in cash. If it is 20,000 and above, to be paid only by means of account credit or by means of DD. Isn't it? Suppose this is told where section 269 of the Income Tax Act 1961. If you are not following the rule, what is the penalty bank has to pay? The amount paid in cash. That all of us know. The question asked was, this is defined in which section? See, so the previous section, so section 269T. If section 269T is not complied with, the penalty is the amount paid in cash, or you and I know. This is defined in which section of which act? This is defined in section 271. This is defined in section 271E, E for elephant. This is defined in section 271 of Income Tax Act 1961. So friends, so less than 20,000 to be paid in cash. If it is not so, so this is told where section 269T of the Income Tax Act. If 269T is not complied with, the penalty is the amount paid in cash you have to give to the Income Tax Department. This is defined where in 271E of Income Tax Act 1961. Okay, question number 155. I want to make it fast. Find the odd statement. So odd statement means wrong statement. Find out the odd statement. So now you see, all DDs above 20,000 to be issued with account payee crossing only. Cash DDs can be permitted up to 49,999 excluding commission and GST. NEFT for walk-in customers to be permitted by accepting cash up to inclusive of 50,000. NEFT for Nepalese who are having account with us to be permitted up to inclusive of 2 lakhs per occasion without any ceiling on number of occasions in a year. None of these. Which is not correct out of these things according to you, which is not correct? According to me, A is not correct. All DDs above 20,000 to be issued with account pay crossing only. That is not the correct answer. DDs of 20,000 and above. What is the option I have given here? All DDs above 20,000. No. All DDs of rupees 20,000 and above to be issued by account crossing only. So which is the wrong statement? Answer A is the wrong statement. All other statements are correct statements. So you should also know what are all the other correct statements. They are all correct statements. Answer A is the wrong odd man. Now, question number 155, answer A. Question number 156. Maximum number of partners. So now quickly we will go through the partnership account. So you will understand. Okay, partnership account you will understand. Then we will come here the questions. The law relating to the partnership form is codified in the Partnership Act 1932. Okay, now number of partners. What is the maximum number of partners in a partnership firm? The maximum number of partners is as per section 464 of the Companies Act 2016. So Partnership Act number of partners is defined in the Companies Act section 464. What is the maximum number of partners? 100 today. But by rules, there are certain rules in that is Companies Act. The rules can, that is by rules, limit can be prescribed, but it cannot be exceed 100 today. As per rule number 10 of the Companies Rule 2014. So Companies Act says maximum number of partners can be 100. But company rule says, rule number 10 of the company says, the maximum number of partners can be 50. 100 or 50, whichever is that is less only, you cannot exceed more than 100. So the company rule can say it can be less than 100 or it can be equivalent to 100 only. So here, as on date, as per the rule of the company's rule number 10, the maximum number of partners in a partnership firm can be only 50. Persons having legal capacity to contract only can enter into partnership. A company or another partnership firm can be a partner in another partnership firm. A minor cannot be a partner. An insolvent person cannot be a partner. An insane person cannot be a partner of a partnership firms. Okay, as per Supreme Court judgment, HUF cannot be a partner. NBFC cannot be a partner as per RBI directions. Minor is admitted only to the benefits of the partnership form and he cannot be a partner. Okay, now let's see the questions. Quickly we'll throw. Maximum number of partners is defined in which act? So in the Companies Act. Question number 156, answer is B. Maximum number of partners is defined in the Companies Act. That is, answer is B. What is the maximum number of partners in a partnership firm as per rule number 10 of the Companies Act 2014 as on today? It is 50, 50. Question number 157, answer is 50. A registered partnership firm. Now the question is, so whether all the partnership firms has to be registered? No, it need not be registered. So that is with whom they have to get registered. They have to get registered with the register of firms. It is not necessary that all partnership firms are to be got registered. Now the question is, what is the advantage of a registering a partnership firm and what is the disadvantage of not registering a partnership firm? See, if a partnership firm is registered, it can sue others. It can be sued by others also. Again, I repeat, if a partnership firm is registered, it can sue others and it can be sued by others also. If a partnership firm is not registered, it cannot sue others. On the other hand, it can be sued by others. So what is the advantage of a registered partnership firm? If a partnership firm is registered, it can sue others, it can be sued by others also. If a partnership firm is not registered, it cannot sue others, but it can be sued by others. Okay, let us see that question number 158 answer. Let us see. A registered partnership firm can be sued by others and it cannot sue others. Cannot be sued by others, but it can sue others. It cannot be sued by others and also it cannot sue others. Point number D is the correct answer. It can be sued by others and it can also sue others. So that is the advantage of a registered partnership firm. Question number 158, answer is D. Question number 159. You have a partnership account with 3 partners. All the 3 partners gave the authority to Mrs. A, who is not a partner, to operate the account. Yes. So all the partners can join and give the authority to operate the account to any one of them. Okay, to any one of them. Answer is none of these. So correct answer is it has to be accepted. Answer is for the question number 159. Answer is D. The correct answer is this authority to be accepted. One of the partners who is not an authorized partner, one of the partners who is not the authorized partner to operate the partnership account gives stop payment instruction for a check issued by the authorized signatory of the firm. Will you accept it? Friends, whomsoever is the authorized signatory, if any partner, whether he is the authorized signatory or not, if he gives a stop payment instruction, you have to accept it. Okay, question number 160, answer is none of these to be accepted. Question number 160, answer is D. None of these. The correct answer is you have to accept it. Question number 161. A minor was admitted. So these are all the questions they are asking, maybe for 2 to 3 or 3 to 4 high levels. So you should know. A minor was admitted to the benefits of the partnership firm for taking benefits of the partnership. On becoming major, within how much period he has to decide whether he wants to continue a partner or not. Within 6 months of attaining majority. Within 6 months of he comes to know that he has been admitted to the benefits of the partnership. Within 6 months of he attaining majority or within 6 months of he knowing that he has been admitted to the benefits of the partnership, whichever is later. Okay, question number 161. Then within 6 months attaining majority or 6 months knowing whichever is earlier. So question number 161, answer is C. Within 6 months of he attaining majority or within 6 months of he coming to know that he is admitted to the benefits of the partnership, whichever is later, he has to say whether he wants to become a partner or not. Question number 161, answer is C. So this is very important. This question also is frequently asked. So question number 162 is, say here I will tell the logic, then you will understand. Let us assume there is a partnership firm in the name of A and B. So you are having an OD account, loan account. So at the time of loan account, the liability in the account is 10 lakhs. Let us assume one of the partner dies. one of the partner dies, when there is a debit balance in the OD account, you should not further permit any credits or debits in this account until otherwise you get a letter of confirmation, okay, from letter of balance confirmation from the legal hands of the deceased partner. Again, I repeat. So you are having a partnership account in the name of A and B. One of the partner dies. Okay, there is a debit balance of 10 lakhs. You should not permit either credit or debits in that account subsequent to the death of one of the partners. You have to permit further debits or credits only after you get a balance confirmation letter from the legal hands of the deceased partner. This is called like your AOD. You have to get from the legal hands. Otherwise, what happens? Let us see. Z is a partner of XYZ partnership firm expired on January 1st when the outstanding liability in the cash credit limit is 20 lakhs was 16 lakhs. So liability is 16.85, limit is 20 lakhs. When he died on 1st April, January, at that time the liability is 16.85. Subsequently, a sum of rupees 12.10 lakhs has been credited to the account and checks for 3.25 lakhs have been debited in the account. What is the liability on the estate of the deceased partner for this loan account after these transactions if balance confirmation letter is not obtained? From whom you have to get the balance confirmation letter? From the estate of the deceased partner. What do you mean by estate of the deceased partner? Legal heirs of the deceased partner. Okay, so if you are not obtained, so 16.85, you permitted credit to the extent of 12.10. So 16.85 minus 12.10, 4.75. So then subsequent debit of 3.25. See, if you have not taken the balance confirmation letter, if you permitted debits and credits, for the subsequent debits of the death of the partner, the legal heirs are not responsible. They are not responsible for this 3.25 lakhs. And any credit has come before you obtain a balance confirmation letter, any credit has come if it is credited to that account, to that extent, legal heirs will be relieved of the liability. You got the point? So there is a liability debit balance in the account. Debits and credits have taken place after the death of one of the partner. You are not taken AOD from the legal heirs of the deceased partner. You permitted subsequent debits. The legal heirs are not responsible for subsequent credits. The legal heirs will be relieved of the liability. So 16.85 minus 12.10 for the balance 4.75 only. The legal heirs are responsible. What is the question? So that is what is the liability on the estate of the deceased partner for this loan account after these transactions if balance confirmation letter is not obtained? The liability is 4.75 lakhs only. The legal heirs is responsible. This is called the rule in the client on case. This is called rule in the client on case. Okay. Which of the following group of persons can become partners in a partnership firm? Question number 163, you take answer as B. Question number 163, answer you take answer B. So let's not waste time. Company account quickly we will go through. Certificate of incorporation is to be obtained for what type of companies? See, there are two types of certificates for a company. Certificate of incorporation and certificate of commencement of business. Okay, for which company certificate of incorporation is required? Certificate of incorporation is like a birth certificate. It is applicable for all types of companies. Whenever a company wants to be started, it has to get a certificate of that is incorporation from the registrar of companies. Certificate of incorporation is to be obtained for what type of companies? For all types of companies. Then as per Amendment to Companies Act 2018, which type of companies to get certificate of commencement of business? Friends, earlier, that is the certificate of commencement of business is to be obtained only for public limited companies. Okay, earlier. But as per the amendment made in the Companies Act 2018, wherever the companies are going for public issue, all companies having share capital, they should get certificate of commencement of business. Again, I repeat, Certificate of incorporation to be obtained for all companies. Certificate of commencement of business to be obtained for all companies which are having share capital from the public. Question number 165, answer is D. Question number 167. All companies registered on or after 2018 has to obtain certificate of commencement of business in order to ensure that they are not shell companies. Yes, SHELL, they are not shell companies. A check issued by the authorized signatory of the company can be paid even after his death. True or false? Yes. So any authorized signatory of a company issues a check. If we come to know the authorized signatory died, you can pass the check. No problem at all. Who will manage the company under liquidation? Official liquidator. Who will manage the company under liquidation? Official liquidator. Okay, question number 169. A check signed by the authorized signatory of the company can be passed or returned when you know that the company is liquidation. If the company is liquidation, the money belongs to the official liquidator. So when the authorized signatory dies, you can pass the check. But if the company is under liquidation, check signed by the authorized signatory should not be passed because the money belongs to the official liquidator. So, question number 169, a check signed by the authorized signatory of the company can be passed or returned. It has to be returned. Question number 169, answer is returned. The operations in the current account of a private limited company with the two directors, one of whom had died, shall be discontinued. Answer is true. If you see the PowerPoint, you will get the correct answer. So, since time is getting short, I am running up. So, question number 170, answer is true. The borrowing powers of the company is given in dash, and the borrowing powers of the company is given in memorandum of association. MOA is memorandum of association, and the borrowing powers of the board of directors is stated in articles of association. MOA and AOA. Charge to be registered within how many days of charge creation? So there are two things, friends, understand. Charge creation and charge registration. Whenever a loan is given to a company, a charge has to be registered with the registrar of companies. Okay. So charge creation means date of loan. Charge creation is date of loan. Charge registration is registering with the registrar of companies. So charge to be registered within how many days of charge creation, that is date of documentation in respect of a loan to a company as per amendment to the Companies Act 2018 within 30 days. Charge to be registered within 30 days from the date of charge creation with the registrar of companies, 30 days. If the charge is not registered within 30 days, it can be registered within dash days from the date of charge creation by paying additional fee. So what do you mean by date of charge creation? Date of loan document. See, within 30 days from the date of loan document, charge to be registered. If it is not done by paying additional fee within how many days from the date of charge creation, from the date of loan document, it can be done within 60 days. Question number 173, within 60 days. Okay. Then, even if it is not registered within the 60 days from the date of charge creation, it can be registered within dash days from the date of charge creation by paying ad valorem fees. So, within 30 days from the date of charge creation, it has to be registered. If it is not done within 60 days from the date of charge creation, it can be done by paying additional fee. If it is not done within 120 days from the date of charge creation, it can be done by paying ad valorem fee. So, question number 174, 120 days. The registered office of a company is in Chennai. Loan is given by a bank branch in Mumbai, in which registered company is charged to be registered. So, wherever the registered office of the company is there, then only the charge creation to be done in Chennai. Whose question number 175, answer is Chennai. Question number 176. Whose responsibility is to register the charges with respect of loans given to a company? It is the primary responsibility lies with the company only. Question number 176, answer is A. All those things I have explained in the PowerPoint presentation. Question number 177. This question they are frequently asking. Understand the question, you will answer it very well. A loan is given to a company with a document that is date of charge creation. Friend, charge creation means date of loan paper. Charge registration is registering with the company. A loan is given to a company with the documents date of charge creation 2nd January by Bank A, and charge is registered in favor of Bank A on 25th January. Within 30 days, charge is registered. Okay. The company executed the documents with Bank B on the same assets on 10th January and obtained the loan. So from when you are taking, he has taken loan from, he has created charge with you, he has created charge with you on January 2019. That is, you executed the loan document. When you have registered the charge on 25th January, within 30 days you have done. This fellow, what he has done, so he has gone to Bank B with the same assets. He created charge on 10th, the loan documents he has signed on 10th January 2019 and obtained the loan. The Bank B registered charge on 11th January itself. You see, Bank A has given loan on 2nd January and registered charge on 25th January. Bank B given loan on 10th January and registered charge on 11th January. Between these two banks, which bank will get priority if the loan becomes bad? So between these two banks, Bank A will get the priority. So even though the charge is registered on the next day here, that is 11th January, the charge is registered only on 25th January. Since the charge is registered by both of them within 30 days of loan paper, it is permitted by law. So since charge is registered within 30 days of loan paper, even though Bank B has created the charge on 11th January, Bank A will get the priority. So question number 177, which bank will get the priority over the asset? Question number 177, answer is Bank A. Okay, sir. Quickly, we'll go through negotiable instrument. We'll wind up this session. It is 4, now it is 4:55. So by 5:15, I'll finish off the session, sir. Okay, my time is given to me till 5:30, but I don't want to delay it. Delay in starting the class, delay the session. I'll quickly make it. As on date, how many sections are there in Negotiable Instrument Act? There are 148 sections and 17 chapters. 148 sections and 17 chapters. Validity of the negotiable instrument reduced from 6 months to 3 months with effect from 1st April. Friends, before 1st April 2012, the validity of a check is 6 months. From 1st April 2012, the validity of the check is only 3 months. It is not valid for 6 months. This is as per which act? This is answer is not. No. Negotiable Instrument Act has not reduced the validity of the check to 3 months. It is still 6 months only. It is not as per NI Act. It is not as per RBI Act. It is not as per Government of India Act. It is as per Banking Regulation Act. So answer is none of these. So the correct answer is Banking Regulation Act. Question number 179, answer is D. Question number 180, form of a check is defined in which act? Nowhere the format of a check is defined. None of these. Question number 181, as per RBI Act 1934, section 31, in India, no person other than RBI or central government can draw, accept, make or issue any bill of exchange or promissory note payable to bearer. These instruments are called what? Indian currency notes. So, as per section 31 of the RBI Act 1934, in India, other than RBI or central government, no one can draw, accept, make any bill of exchange or promissory note payable to bearer. These instruments are called Indian currency notes. Okay. Question number 182. A check written in rupees 1 crore in words and figure column is blank is presented for payment. So in word column 1 crore is there and figure column amount is blank. You should not pass the check. Okay, it is not amount in words and figure differ. When the amounts in word, figure and differ, one amount here, one amount there. But here in the word column, in figure column is black. Word column is 1 crore rupees, 1 crore is there, but figure column is black. This is not amount in words and figure differ. This is called inchoate instrument. Any column in a check is blank other than drawer signature. Any column in a check is blank other than drawer signature. It is called inchoate instrument. Inchoate instrument is defined in section 20 of the Negotiable Instrument Act. Inchoate instrument is defined in section 20 of the NI Act. Who can fill up the blank column? Anybody other than the banker can fill up the blank column. So any instrument without the drawers other than the drawer signature is blank. It is called the inchoate instrument as per section 20 of the Negotiable Instrument Act. Who can fill up the blank column? Any person other than the banker can fill up the column. Okay. So section 20. Question number 183. In a check, the amount in word is called the legal amount. Amount in word. Question number 183. The amount in word is called the legal amount and the amount in figure is called the courtesy amount as per CTS 2010 guidelines of RBI. So legal amount and courtesy amount. In a check, if both the words bearer as well as order are written and none of them are deleted, the check will be considered as a bearer check. So question number 184, answer is it is a bearer check. Question number 185. If nothing is mentioned about a check being a bearer or order, you should be treated as payable to order. Question number 185, answer is order. Question number 186. When the payee of a check has become insolvent, the check to be passed since the paying banker is concerned only with the drawer. To be returned with the reason payee's title require confirmation. Get drawer's confirmation and pass the check. None of these. Friends, please understand. Your account holder, that is drawer, has issued a check one Mr. X. Okay, your account holder, he is the drawer of the check. He has issued a check one Mr. X. X is the payee. The check comes for payment. When the check comes for payment, you come to know Mr. X, the payee, has become insolvent. Nothing has happened to your drawer. Your drawer has not become insolvent. Your drawer has not died. Everything is pakka. But you come to know that the payee has become insolvent. Whether you can pass the check, nothing has happened to the drawer, or you have to return the check. Friends, please understand. Once you come to know that either the payee or drawer becomes insolvent, the money belongs to the official receiver or official assignee only appointed by the court. The person who has become insolvent here is payee. Don't think that I am not responsible for a payee. I am responsible only to my drawer. So here, this check also to be returned with the reason that is payee's title require confirmation. So question number 186, answer is B. Question number 186. So people will always write answer A for question number 186. Pass, since the paying banker is connected only with the drawer. No. You are also connected with the payee because the payee has become insolvent. The money belongs to the official receiver only. Question number 186, answer is B. Question number 187, which is the odd man out with regard to dated 31st number, which is not correct. What do you mean by a check dated 31st November? It is not in calendar. This is called check bearing impossible day. This is called check bearing impossible day. When you can pass a check bearing a impossible day, 31st November is not, it is a check bearing impossible day. If the check comes for payment on 30th November, and if the 30th November is the working day, again I repeat, a check bearing an impossible date, example 31st November. If the check comes for payment on 30th November, and if 30th November is the working day, pass the check. Otherwise, you have to pass the check only on 1st December and afterwards. Do not pass the check on 29th November. Okay. Which is the odd man out with regard to a check dated 31st November, which is not correct. Can be paid on 30th if it is a working day. Correct. If 30th November is not working day, it can be paid on 29th November if it is not working day. Wrong. That is not correct. If 30th November is not a working day, it has to be paid on the next working day. That is also correct. This check cannot be handled as there is no such date 31st November. Options are A 4, B 2, C 2 and 4, D 1 to 4 are. Question number 187. Your answer is C. 2 and 4 are correct. What is 2? If 30th November is not a working day, which is odd man out, which is not correct. So first is correct. It can be paid on 30th November. It is not odd man out. 2 is odd man out. If 30th November is not a working day, it can be paid on 20th November. No. Then 4 is the odd man out. This check cannot be paid until there is no date. So 2 and 4 are odd man out. 2 and 4, your option is C. So this type of options also they are giving. Question number 187, answer is C. Question number 187, answer is C. Question number 188. An account was opened on 20th March after complying with the KYC norms and checkbook is issued in this account on 30th March. A check dated, you opened an account on 30th March, 20th March, checkbook issued is only on 30th March. But he has issued a check dated 1st February. This check comes for payment. Whether you will return the check or you will pass the check when all other things are in order. Friends, you don't worry on the date of receiving the check. Don't worry when the checkbook was issued, when the account was opened. That is not our issue. Whether the check can be paid, it is not a stale check. It is not a post-dated check. All other things in order, you can pass the check. So you have issued a check on that checkbook only on 30th March. He has put the date of the check on 1st February. This is called anti-date check. Okay. This is called anti-dated check. What he will do, the check to be returned for the reason the check is bearing a no, to be returned for the reason check bearing a date no, to be passed after getting confirmation from the drawer no, none of these. None of these is the answer. The check to be passed. The check to be passed, no other issue, none of these. This is called anti-date check. Question number 189. A stale CTS check can be revalidated for how many times? See, normally that is in a CTS check, no alterations is permitted other than the date column. So why alterations permitted in date column? For revalidation. For any number of times, date can be revalidated provided space is there. Okay, once cannot be revalidated, but there no restriction. So question number 189, answer is C. Question number 189, answer is C. Question number 190, a check favoring impersonal payee, say Bhagavan Shiva. So impersonal payee, there is no Bhagavan Shiva, there is no physical person, no, or Bhagavan Venkateshwara, no physical person. So it is an order instrument. You have to see whether it is an order instrument or it's a bearer instrument. So a check having impersonal payee or bearer or order. If it is or order, the check to be returned. If it is or bearer, you can make the payment to the person who is presenting the check. So, if the check bearing an impersonal payee name, if it is an order instrument, the check to be returned. If it is a bearer instrument, it can be paid to the person who is presenting the check. Here, draw a Bhagavan Shiva identification, return the check. 190, answer is C. 191. When sufficient space is not available in a negotiable instrument, the endorser can attach a slip of paper and make use of it for further endorsement. This paper is called allonge. A-L-L-O-N-G-E. So question number 190, answer is this paper is called allonge. So the allonge is defined in section 15 of the Negotiable Instrument Act, section 1.5. Question number 192. All the sections are important sections I have given in the PowerPoint presentation. Collecting a check for a customer who is not the true owner of the check is called conversion. Collecting a check of a customer who is not the true owner of a check is called conversion. Question number 192, answer is conversion. Section 131 of the Negotiable Instrument Act gives protection to the collecting banker in respect of conversion. Protection under section 131 is available to the collecting banker in respect of collection of which of the following checks? Uncrossed checks deposited in the check drop box or crossing is done by the collecting banker. Yes, protection is available. Collecting a cross check for an account holder who opens the account with that check. Yes, it is available. Collecting a cross check to a person who is not having any account. No, protection is not available. None of the given options. 193, correct answer is C. 193, correct answer is C. 194. Which crossing is not defined in the Negotiable Instrument Act? Account payee crossing is not defined in the Negotiable Instrument Act. So, which one of the following? So, question number 194, answer is C. Question number 195. Which of the following is a material alteration? So, answer is that is holder fills the amount column as rupees 10 lakhs, whether the drawer has filled the word column rupees 10,000. It is not a material alteration. Anybody can fill the amount column or word column. Holder converts a bearer check into order check. It is not a when a check bearer is converted into order, it is more protective to the bank. So it is not a material alteration. Holder converts special crossing into general crossing. That is a material alteration. Then, name of the payee filled in by the payee himself in front of the banker. Anybody can fill in the blank column. Question number 195, answer is D. So, number 3 is the that is material alteration. All other things are not material alteration. Question number 195, answer is D. Question number 196. Within how many days suit to be filed by the payee against the drawer if check is returned for want of funds as per section 138 of the Negotiable Instrument Act? 30 days from the date of return, 30 days from the date of getting confirmation from the bank that check is returned, 30 days from the date of the check, 1 year from the date of return, none of these. The answer for this question is none of these. Then what is the correct answer? 30 days from the date of cause of action arises. Again, I repeat. So, all are 30 days only. The correct answer is here. The answer for question number 196 is none of these. What is the correct answer? From the 30 days from the date of cause of action arises. What do you mean by date of cause of action arises? When the check is returned, the payee has to give 30 days notice to the drawer, asking him to pay the money within 30 days. If within 30 days he has not paid the money, the payee has to wait for another 15 days. Okay, even after the end of the 15th day, if the money is not paid, so the end of the 45th day is called the date of cause of action arises. From the date of cause of action arises, within 30 days, suit to be filed. Okay, so from the date of within 30 days from the date of cause of action arises, question number 196, answer is E. As per section 143A of the Negotiable Instrument Act, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant not exceeding 20%. So court wants to take up the case. Court will say the drawer of the check, your check is returned, first to pay 20% to the payee. So 20% of the check, and it has to be paid within 60 days of the order, and it can be extended by another 30 days. So 20% of the amount court will order to pay. This is as per section 1. These are all the recent amendments in Negotiable Instrument Act. This to be paid within 60 days, or court can say you can take another 30 days. So if the check is returned, payee is going to the court. So within how many days he has to go to court? Within 30 days from the date of cause of action arises. Then court will ask the court, sir, ask him to pay compensation immediately. After the balance he can pay after the trial. So court will order him to pay 20% of the amount of the check within 60 days or within 90 days maximum. This is given in section 143A of the Negotiable Instrument Act. Then question number 198. If the drawer of the check is acquitted, for example, finally court has found out first 20% he has paid. Court has found out the drawer has no fault at all. Then the court will direct the complainant to repay the money. Already 20% is paid, So the court will say, repay the money back to the drawer. So within 60 days. So along with interest. What is the rate of interest? If the drawer of the check is acquitted, the court shall direct the complainant to repay the drawer the amount of interim compensation with interest at bank rate. as published by Reserve Bank of India. So answer is bank rate. So first 20% is paid, Finally, it is proved that the drawer is not any fault, is acquitted from the case. Then the complainant who got 20% of the money has to return the money along with the interest. What is the interest he has to pay? The applicable bank rate prevailing at the beginning of the relevant financial year within 60 days from the date of the order or within such other period not exceeding 30 days as directed by the court. Okay, sir. Now the 20% is 143A. Then if the acquitted is acquitted, the 20% to be returned to the drawer with the rate of interest of the bank rate at the beginning of the financial year is 1st April. What is the bank rate? At that rate, the amount has to be returned within 60 days. Then suppose in an appeal by the drawer against the conviction under section 138, the appellant court may order the appellant to deposit. For example, first the court has asked the fellow to pay 20%. He has paid. Then the court has proved that the drawer is wrong. He has to pay the balance money to the that is payee. Then the drawer is going to the appellant authority and he says, sir, I want to appeal. So first I have paid 20% to the payee. Then finally the court has given the order. Then I have to pay the full amount to him. So I am not happy with the order of the court. Then he has to go to the appeal. So after going to appeal with the court, then at the time of appealing, accepting the appeal, then the court will say, you pay another 20%. See, in an appeal by the drawer against conviction under section 138, the appellant court may order the appellant to deposit such a sum which shall be a minimum of 20% of the fine or compensation awarded by the trial court, provided the amount payable under the subsection shall be in addition to any interim compensation by the appellant under section 143A. First 20% paid under 143A. Now he goes for appeal. At that time, again 20% he has to pay. So this is defined under which section? This is defined under the latest section of the Negotiable Instrument Act, section 148. Question number 199, section 148. Okay, question number 199, answer is 148. Question number 200. Return checks are to be sent to the customer within how many days? Within 24 hours. Within 24 hours. As per RBI guideline, checks to be scrutinized under ultraviolet lamp for amounts 1,000 for cash checks and 5,000 for others. This is our bank guideline. Point number A is our bank guideline. Reserve Bank of India guideline is amount exceeding 2 lakhs. Question number 201, answer is C. Question number 201, answer is C. Question number 202. The balance in the account is 10,000. A check for rupees 10,000 favoring Mr. X and 10 checks each for 10,000 each favoring various individuals come clearing at the same time. Which one to be passed? So here first you have to see the checks are favoring whom. Any check is favoring to a that is a statutory authority, that the check to be passed first. Here what has happened? A check is 10,000 favoring Mr. X. It is not favoring a statutory authority. Then checks of 1,000 each favoring various individuals. Whether you will pass the 10,000 check or whether you will pass the 10,000 checks, you have to pass the 1,000 rupees checks, all the 10 checks, and return the one check favoring 10,000 rupees favoring X, because by passing the 10 checks, you are taking care of your customer by clearing many of other liability of the customers. Only one customer is outstanding, 10 customers liability you clear. So pass the check of 10 checks of rupees 1,000 each. Question number 203. Balance in the account is 5,000. 2 checks of 5,000 each favoring Mr. X and Mrs. X comes in clearing on the same time on a day. Check favoring Mrs. X bears a date before the date of opening the account and the other checks bears a date after date of opening the account. Both the checks are in order. As a paying banker, which is your position? So balance is only 5,000. 2 checks are coming. So favoring 2 people. Which check you will pass? One check is dated. So you have to see which is the check which is older date, because that becomes stale quickly. No, you have to see which check is having that is older date. That is check to be passed. If both the checks are both same day, if both the checks are same date, then you have to pass the check which is bearing the earlier serial number. Again, I repeat. So two checks are coming 5,000. One check is favoring the date before the date of opening the account, and other check bears a date after opening the account. So don't worry about date of checkbook, etc. So the check which is bearing the older date to be paid. If the dates are the same, then pay the check which is having the earlier serial number. So question number 203, pay the check with older date, that is the check with the date before opening the account. Pay the check with older date, that is the check bearing the date before opening the account. Question number 203. Question number 204. Account payee are not negotiable crossing or directions of the drawer to the paying banker, collecting banker. Answer is collecting banker. Question number 205. When both duplicate and original duties are presented, which will be passed? You have to pass the duplicate DD. Question number 205, duplicate duty. When original is presented before duplicate, pay or return the original. When the original is presented before the duplicate, return the original. 206, answer is return the original. Duplicate DDs, this question they asked last time. Duplicate DDs are to be issued to the customer within a fortnight. Within a fortnight, here fortnight is not given, say 14 days. So duplicate DDs are to be issued to a customer within a fortnight. That is, fortnight means 14 days. If it is not paid within 14 days, what is the penalty bank has to pay? The penalty bank has to pay is for the delay period. What is the fixed deposit interest rate for the delayed period? It has to be paid to the customer. That question also you should not miss. Within a fortnight, that is within 14 days. If it is not paid, the penalty bank has to pay to the customer is the fixed deposit rate for the delayed period. Question number 208. When a check is presented before bearing a date as per national calendar, the date will be assigned from which calendar? Gregorian. The date has to be ascertained from the national calendar is, so there is Hindi, if it is mentioned, the date is mentioned there. The date will be assigned from which calendar? Gregorian. Gregorian. Under CTS 2010 standards, the term legal amount stands for amount in words. Amount in words. Question number 210. Whom of the following is not competent to endorse a check? Minor can endorse a check. Then any minor can endorse a check. Insolvent person can endorse a check. An illiterate person can endorse a check. All are competent to endorse a check. Question number 210, answer is E. Question number 210, answer is E. Question number 211. Which of the following is the most appropriate with regard to general crossing of a check as per NI Act? Words written within two transverse parallel lines. Words written within two transverse lines within two lines or without lines. Two transverse parallel lines with or without words. All are correct. Friends, I will tell you what is a general crossing. General crossing means there should be two transverse parallel lines on the face of the check. Within the transverse lines, you can have undergo, not negotiable, etc. So general crossing, two transverse parallel lines across the face of the check. Then what is a special crossing? That is the word name of a bank on the face of a check with or without two lines. That is a special crossing. What is account payee crossing? The word account payee only with two lines or without two lines is called the account payee crossing. So general crossing means two transverse parallel lines with or without words. So question number 211, your answer should be C. Two transverse parallel lines with or without words. Question number 212. In the case of a ECS, instruction is dishonored for insufficient funds. Imprisonment, so you know, if a check is returned and the court has proved that fellow is wrong, so what is the punishment the court will give? 2 years of imprisonment or double the amount of the check or both. Similarly, if the ECS is, that is as per Negotiable Instrument Act section 138, if a ECS instruction is returned, so that is also the punishment is also the same. 2 years or double the amount of the check or both is provided in which act? This is provided in Payment and Settlement System Act. Question number 212, answer is B. Question number 213. Which crossing takes the future of Assam defective title of the transferee, not negotiable crossing. This they are asking again and again, not negotiable crossing. 2014, recording the fact of dishonor of a bill by notary public is called noting as per which section of NI Act? Section 99. Noting is as per section 99. Getting dishonored bill of exchange noted from the notary is called noting, section 99. The certificate issued by the notary is called protest. The certificate issued by the notary is called protest. It is as per section 100 of the Negotiable Instrument Act. So 99 is noting, 100 is protest under section 100. Question number 214 is answer is 99. 215 answer is 100. As per RBI guidelines, positive pay is mandatory for all. It is mandatory for all check amounts of rupees 5 lakhs and above. None of these. So option is here, none of these. The correct answer is rupees 5 lakhs and above. Question number 27. While making cash payments to third parties against bearer check, if the amount is rupees 10,000 and above, if the amount is 10,000 and above, the identity of the payer to be established by obtaining suitable KYC documents in our bank. 10,000 and above, answer is B. Question number 207, answer is B. Question number 208. An account is operated A, B, and C jointly. A check is issued signed by all of them. Who can give stop payment instructions to the bank on the check issued by jointly by them? All of them jointly can give, by any one of them can give, by any two of them can give. So answer is 1, 2, 3. Where is 1, 2, and 3? So which is the correct option? So answer is C. 1, 2, 2, 1, 2, 3, any. 218, answer is C. Question number 219. Which endorsement makes the instrument payable originally to the order? It becomes payable to bearer. Endorsement in blank. Endorsement in blank makes the instrument payable originally to the drawer becomes payable to the bearer. Endorsement in blank. Friends, sorry I got taken a little more of your time. With this, we are winding up the session today. So next session we will see, we'll take up all the policies of the bank one after the other from the next session onwards. Thank you very much. So good night. Good evening.